My lord, this repurpose is taken up this week. The contempt action will be initiated next week. I have given multiple memos, my lord.
My lord, I have a small item 36. The repurpose filed by the government. That is, we are. Yes, that is what. My lord, extensively hard there.
We may reach today.
My lord, 36 may be taken up.
May I please also? Item
25.
I'm sorry.
Item number 25 may be published.
Item number 45 may be permitted to withdraw.
Oh, by all means.
47 also permitted to withdraw.
No.
Already we have filed discussion. Already
46, my lord.
30 permitted to withdraw.
Not with Liberty, my lord.
Item 30 permitted to withdraw.
My lord, we have already filed an IA, my lord.
Let them all exhaust.
47, my lord, please, 46.
Attorney General will mention about this.
May I have your lordship's attention for a minute? Yeah, this is that Tata and that those matters relating to the challenge to the virus of the rules. Your lordship will recollect, Mr. Dr. Singhvi and Gopal Subramanian appeared in this matter.
Yes.
And your lordship fixed it on 3rd of December. I made a request to my learned friend the other day, 3rd of December, as a personal inconvenience for me. Therefore, I'm still told Mr. Rakesh Dwivedi is yet to conclude his arguments. So if they are able to conclude their arguments on 3rd, I would probably request the court to give me another date on 12th, if possible, subject to lordship's convenience. I would like to come physically and assist the court if possible.
That will be very.
So on 3rd, when the matter is taken up, perhaps a request will be made to your lordship so that some adjustment can be made on my behalf.
If the matter continued for a longer period, then there's every possibility of something being faded from the memory. So
I understand that, but third and fourth, I have some personal difficulty. I would not be able to even virtually appear. There's some parted matter where I have to be here. And
when we are taking up those matters,
I believe you are taking it up on 3rd, I believe.
We list 64 listed, my lord.
let us see on 3rd what happened.
Very well. So Mr. Pari will be there to make a request on my behalf. And
What happened on 3rd?
very well. Very well.
15 this also.
Not
No,
50.
Even earlier,
Don't tax
any
the
date
bench.
earlier is okay.
Don't tax the bench.
Any earlier date is convenient
Yes.
for the court. I would not mind.
Let us see if we can fix it on 10th, whatever. But let us see on 3rd what happened.
I'll request my learned friend to appear on 3rd and make a request.
Yes. Pass
Very
on the memos. Yes.
Very well. Very well.
Honorable Supreme Court has requested your lordship to take up this matter. That is, I'm reading the order with the memo, my lord.
Item. I am requesting item 49, my lord. That is a blacklisting contractor.
Let us see, sir.
Just one.
You just permit us to roll the.
Yes.
So we will be able to read. Don't worry.
It got deleted, my lord. That's my matter got deleted today.
No, because we have started from the last week.
Yes.
That all the category of the matters would be listed on a particular day. So your category today may not be your category day.
And I'm just.
So it will appear on that day. Don't worry. So,
Obliged.
vacating application is there. Yes, next.
Weekly Delhi fresh admission item number 1.
Give 5.
And then it's permitted to file a paper.
Oh. Give the memo.
Yes, I'm present.
Item 2.
Fatal defect which is incurable in nature and prays for withdrawal of the same with the liberty to file afresh. Allowed liberty.
Regarding the disbursement of inherent amount, which has been deposited report of the initial affinity. Why is executing the
So the difficulty, the difficulty is, have you seen my judgment, which I delivered last week?
They have also agreed, so far as the annexure 1 is concerned.
Is there admission on their part?
Nobody is agreeing that, but it is Mukti Joel agreeing. MCL.
Can you show me that what the which can be termed as admission?
Annexure 1, my lord, page 9, have internal correspondence, they have agreed for disbursement of the payment. But till date, they have not disbursed it. Annexure 1, page 9, man. A letter given by the Deputy General Manager to the General Manager regarding the refund of the amount.
Oh, this is what is there. No, please take. Notice 2 weeks. Next.
Adjourn to 15th December. Item 3.
It's an application challenging illegal and arbitrary recovery of finance royalty amount from the bill of the petition. It's already covered by the issue already been settled. Any number of cases are filed. And also may kindly turn to annexure 8 at page number 33.
Where is your
It's only across the authority and the authority will pass an order. That says page annexure 8 at page number 33.
Is this relatable to royalty,
Right, enactment, reduction of enactment.
enhancement of royalty?
Yes, sir.
what is this
A police and that's
what is this Kuli Charan Das case? What is that?
My lord, enhancement of royalty. Earlier, royalty was charged under the Odisha minor mineral rules 1960. Then subsequently, that rule was amended in 2016. The judgment which my learned friend is referring to, that is that annexure 5, was passed when some notifications were issued enhancing the royalty. So that is why it was challenged that that they cannot do without making an amendment into the statute. But in 2016,
I think Apuricharan Das case that proceeded on the basis of amendment being carried out in 2004.
yes,
In retrospectively, you could not have enhanced
yes,
the agreement which you have entered
yes.
at the time of lease.
But
Right.
here,
Am I correct in
Well-
this proposition,
well,
which is Apuricharan Das?
yes, but here, post the amendment of post the repealing of 1960 rules, the new rule came into force in 2016, December 2016.
December, 14 December
So
2000.
how they are agreed, Malik? Now, as per rules, they are charged with the royalty.
No, this is the page 22 is a order of the Akuli Charan.
2006 supplementary to OLR.
So where is the
Where is
judgment?
that? First. What is the rule now, Mr. Das? 2016 rule? Which provision?
Your lordship may also. 32. Liabilities for failure of penalty, rent, surface rent, additional charge, amount of contribution payable. And here the writ petition, if your lordship will see, it does not give rise to any cause of action. What is the cause of action? What he has challenged in the restitution. He has only made a representation to the authorities.
Only grievances that may also be given. I'll also see the chance of this. It will be just.
There is nothing record to show that he is aggrieved by any orders passed by the authorities.
Here, this additional charge was not there.
Yes.
In rule 28 of 2004 rules,
Yes.
this additional charge was not. This additional charge, you say additional royalties.
Yes.
Yes, sir.
Additional charge is royalty is calculated based on the additional charge. So Lordship may 27(7) your Lordship may kindly see. 27(7). Rule 27(7). Once the bidder is selected and he is issued with a form F as per Rule 6. Rule 7, within 15 days of such intimation, the selected bidder shall be required to convey his acceptance of the terms of condition and to deposit an amount which shall be calculated in such a way that it shall be given equivalent to 1/4 of the total amount of royalty and additional charge and the amount of contribution payable to the District Mineral Foundation on annual minimum guaranteed quantity, taking together reduced by the amount earnestment. And so far as the royalty is concerned, the Lordship will find in the schedule appended to the rules. For sand quarry, it is 35, and for stone quarry, it is 120 rupees money.
130.
And after amendment, after the commencement of the new rule, these provisions have been incorporated. It is there in the rule. And writ petition does not disclose how they are aggrieved, by what action of the authorities they are aggrieved with us. There is nothing on record to show that. Those amounts, as alleged in the writ petition, those amounts have been deducted by P number 5 and 6, for whom I think my young friend is representing railway authorities, Southeastern Railway.
This procurement is all. So how can,
So thus the agreements appears to be prior to coming into force this 2016 rules. 2016 rules came in
December?
December.
And the agreement, I believe, was entered into, on agreement was entered into 30th of May 2016, when the letter of acceptance was issued.
Letter of acceptance was on 30 May 2016.
Correct.
Agreement on 27/10/2016.
It was
prior to 2 months prior to.
Whatever. Now, what? Have you noticed that? How you are taking advantage of Akuli? It rather goes against you.
Actually, is in a context when 2004 rules were not there. Agreements were prior to 2004. So the answer was also there in the judgment itself.
Have you seen, if you go by an Akuli decision, then rather what you are claiming is just contrary to what has been held there. Your contention is that the moment the agreement has come prior to 2016 rules, then whatever the royalty which was paid as on, which is charged as on the date of an agreement, that would continue. Any enhancement under 2016 rule will not apply.
It's perfect.
Have you seen so? There says that yes, what you say may be correct, but if you have procured the minerals after the 2016 Act came or rules came into, you are bound to pay. So really it goes against you. We are not making any comment on that, but simply going by your version. Look at it, this judgment, and you say Akuli. When you cite a judgment, you should be very meticulous in this. The first question is whether the Odisha Minor Mineral Concession Rules 2004, published in the official gazette on 31st of August 2004, would apply to an agreement entered into before the said date. That's your condition. And the answer is, therefore, the first issue is answered in negative. And we hold the 2004 rules that apply to all procurement of a minor minerals made by the petitioner on or after 31st of August 2004, irrespective on the date on which the agreement was signed. So if this is the answer, then your contention goes contrary to Akuli. You have procured after December, then you are liable to pay under 2016. What? So, and your prayer is that as per Akuli. So we are deciding as per Akuli saying this.
Amendment prayer.
Sorry? What amendment prayer? No. No amendment prayer.
Or is withdraw with liberty to file the prayer.
Sir, whenever you draft, whenever you claim, you should be very careful when you're taking shelter under a particular judgment. Then you should read the judgment line by line, word by word. And it is really going against you.
And withdraw with liberty to file the prayer.
And sir, fine. Rule 28 is extracted and rule of 2004 rules. That is also there. So have you checked up? Have you compared rule 32 of 2016 with 28 of 2004?
I think.
And there are rules, procedural.
law.
Item 3 is withdraw. Item 4.
Give memo.
File.
Quickly,
Give memo.
Item 4.
But it actually two identical matters to that, where the present petitioner is also the petitioner that's pending. That relating to that money claim.
So let it be disposed of. They will
suffer the same thing. I'm ready.
So what is the difficulty?
The difficulty is that that relating to that maintainability of the writ petition relating to money claim.
It's not a money claim, it's an admitted due, annexation 19.
Have you seen my judgment? I have delivered last week.
That Mamta Behra is not pronounced.
It's already there. I have signed it. Oh, it's about to sign.
It's not. It's judgment is to third. These all matters are also coming on third. So
Third cup.
number.
Yes. Nowadays I am forgetting. Give it on third.
Item 4 adjourned to 3rd December.
I stand on a different footing, but I will take it up in that day.
Adjourned to 3rd December. Item 5.
May please your lordship. I am on behalf of the petitioner, madam, petitioner, that the lordship read petition for illegally and arbitrary tender possession that which was held and Tahsil office Soro by tender notice number 1800 on dated 1/9/2025. After all, as for tender notice, sir, annexure 1, page number 12, sir, the sealed quotation are invited for registered travel agency for providing one number of Bolero BS6 diesel white color, sir. My lord, the interested travel agencies have submitted their tenders in a sealed envelope, superscribing on the top of the sealed envelope, and tender along with all papers should reach the office on and before 9/2025, sir. My lord, the tender will be open on the same day at 4 p.m., sir. But it is surprisingly, the tender was not open that day, and the tender was open on 11/2025 at about 11 a.m. instead of 9/2025 4 p.m., sir. This is surprisingly is a change in tender conditions that must be, sir, published in favor violates, sir, Article 14, sir.
What Article 14? How it is Article 14? Did you submit your tender on 9/9?
Yes.
Did you submit your tender on 9/9?
Sir, tender notice number, sir, 5800 dated 1/9/2025, sir.
Let's see, submitted the tender.
Yes, that is what I wanted. She submitted the tender?
Sir.
Yes. That is what I am asking, and he is avoiding the answer. Submitted the tender. Disqualified?
Sir, no, sir. Sir, subsequently.
Disqualified?
Disqualified. Subsequently, sir, my second prayer is, sir, your lordship, I have submitted one pen drive, sir. A pen drive with the video of all tender process. Tender process are, sir, available in the pen drive, sir. And at the time of tender opening, the found, sir, one tender paper was torn, and again it is received, which are admitted by the Nazir one Pandit Himanshu Panda, sir, admitted that at the time of receiving the tender from the post office, the person namely Goino broke the tender, and thereafter Bodababu resealed it, sir. Once
Who received it?
One torn tender papers are usual.
He was also present on that day.
Yes, Miller.
On 11th.
Yes, Miller. Page 5, her signature is there. Page 5.
Sir, I am vehemently opposed when opposed to before the Tahsildar sir, but Tahsildar not listening anything. I am all on anything. All things are recorded in the pen drive, sir.
Simply because if frivolous allegations are made, do you think that everybody should listen or should act when everything is transparent? Do you think that it has to be done?
Nothing which is transparent, sir. All things are available in the pen drive, sir.
Yes, what is the pen drive? They have justified that instead of on 9/9, they have opened it on 11/9. You were personally present on 11/9. In your presence, unsealed tenders were opened, and thereafter they have taken a decision in front of everybody. You may raise an objection when the rejection comes.
Sir, I have already objection before Tahsildar and sir already sir before the district magistrate our collector sir and file an FIR before the SORA, but no one responds, sir.
Yes, an unsuccessful bidder
Item 6.
My lord,
Yes,
which tender paper was tempered and that tender paper was secure, sir,
make it stringent. Deposit must be within 2 weeks.
Item 6.
Yes. Next matter.
May I please, Your Lordship?
Yes.
Lord, here is the case, my lord, the minor levy compensation was imposed. Only
What?
to the levy, the post completion of work, the levy compensation was imposed only to
Levy compensation.
Yes, my lord, under the OPWD code and to deny the price escalation, my lord. Your Lordship, can you have
What is this levy compensation?
Lord, the damage has been imposed.
So that I understand that the damages can be claimed, or levy
what-
compensation. I'm not very much accustomed with this
compensation. My lord.
expression. Eh?
If the word is, my lord, recommendation as compensation, my lord.
No, it is levy
Of compensation, levy of compensation. Oh, sorry, levy of the compensation has been charged, my lord, only to deny the price escalation.
It's 100,148 is the including order.
One.
No, this is not informed order. The Lordships kindly see let me complete. Lordship kindly annex to 7, your Lordship.
No, you are challenging annexure 1.
One, yes, sir.
Where is annexure 1?
Page 44, 0, your Lordship.
Page 44.
Page 40,
40.
your Lordship. Look, under the provisions of para 3.5.b of OPWD code,
Extension of time is hereby approved.
as per the recommendation of the Chief Engineer, Rural Sector Baleswar, in favor of the Niranjan Pradhan, A-class contractor for the work construction of Adarsh Vidyalaya at Arjunpur in the district of Baleswar for the year 2018 in respect of agreement number 2019-20 of the super.
So they have said that this is on account of a delay in completion of the work. Even if the extension of time is awarded, no compensation can be given. They have quoted this clause 4.
Your Lordship. Plus 2, your Lordship. Your Lordship, this is regarding extension of post extension of time. This honorable court pass an order after completion of work, when they are granting extension after no penalty has been imposed. That matter referred to Supreme Court. Supreme Court in Radhesam Agarwal case say that you can't exercising 3.5.b of the OPWD code.
That is sanctioned or allowed.
State of code.
Once sanction
Sanction is allowed,
is
post you
allowed,
can't impose, my lord. There are lot of kind.
No, that is true. What is the meaning of the word extension? When it is an extension, it is really a prolongation of a time which was initially fixed by for execution of the
Yes.
work. So once it is extended, it is really a prolongation of the original period.
Yes, sir.
So if you have completed within the extended time, then there cannot be any imposition of penalty. We are not concerned. But here you are claiming a compensation for what?
Yes, they claimed, your Lordship. Your Lordship, kindly.
What they claim means?
They have charged a compensation, my lord. Superintending engineer informed that with a levy of compensation of 34,000.
Where is this called clause 4?
Lord, clause 4, they have, your Lordship.
Where is clause 4 of P1 contract? I do not know. What is this P1 contract?
Part
Where the
of this P1 contract is formatted here.
No, my lord. They have only page 84 to clause 2A quoted. There is no contract was provided. Page 284.
Sir, where is this? You have quoted where we want to
It's
look
not
at the clause 4. What is this clause 4?
Clause
Where
4,
do I get it clause 4?
yes.
Class 4 and class 2A. Two small areas.
Sir, you are appearing. Show us. This is your order. You have to justify.
But actually that clause is not available.
Where do we get it? We want to look at it.
I will bring that back.
Next Monday, you bring.
Yes.
Show us.
8th December. Item 6.
There is no
Item 7.
prescribed in this,
No.
like F2 contracts.
Yes, next 7.
Item 7.
Lordships, the impugn article is at page 35, 347.
What?
347, page 347.
Impugned order.
Impugn order. Annex 25. Regional order, your lordships.
340?
7.
Yes.
Your lordships, challenge this order because on a very important question of law, which would be, your lordships, that this is a show cause, which was issued after there was an amendment in section 21(5) of MMDR Act. Your lordships, if I be allowed to take your lordships to that amendment.
What?
Your lordships,
Can you,
your lordship, in
rephrase?
this case, the show cause which was issued because my production or raising of the ore was more than my EC limit.
Okay.
That was the subject matter of the show cause. They said, as because you have violated the EC limit, therefore you have to pay the cost of the ore under section 21(5). But of the
MMDR Act.
Yes. But this show cause was issued to me after the MMDR Act was amended. Now, your lordships, if we read it and then.
Where is that?
Your lordships.
Which provision?
21(5), your lordships.
That's the head note is the penalties.
Lordships. But that provision has been interpreted by the Supreme Court being compensatory in nature, not penalty. I'll come to that judgment also. Now, your lordships will see 21(5), whenever any person raises without any lawful authority any mineral from any land, the state government may recover from such person the mineral so raised, or where such mineral has already been disposed of, the price thereof, and may also recover from such person rent, royalty, or tax, as the case may be, for the period during which the land was occupied by such person without any lawful authority. Now, lordship, the amendment.
Lawful authority has been explained or clarified anywhere?
Yes, your lordship, this particular provision was actually taken note of in the common cause order, in the judgment, your lordships. I'll come to that judgment. But your lordships, there is a change. That is the amendment which happens in that explanation is introduced.
That is in 6.
Your lordships, may I just read it? On and from the date of commencement.
This explanation is below
6. Yes, but it's explaining what lawful authority means without lawful authority. On and from the date of commencement of the Mines and Mineral Development Regulation Amendment Act 2021, the expression raising, transporting, or causing to raise or transport any minerals without lawful authority occurring in this section shall mean raising, transporting, or causing to raise or transport any mineral by a person without a prospecting license, mining lease, or composite license, or in contravention of the rules made under section 23C, which would be like the 2007 rules that we have in our state, which controls the entire transportation of the mines and minerals. Your lordships, may I give your lordships the objective portion of this amendment, your lordships. We've got a Xerox copy. Your lordships will find that page 6 of that. Page 6, your lordships. X. To amend section 21 of the Act so as to clarify the expression without any lawful authority in order to limit its scope to violation of the said Act and rules made thereunder. The amendment will clarify and certainty to the mining sector.
That is a bill, that's an object.
Yes, your lordships.
That's an object.
Obviously, your lordships have already got the point why I'm hinting on that object and hinting on the word to clarify, because I intend to put forward this, that this basically is retrospective in nature. Of course, I'm conscious of this fact that even when a provision is retrospective, the legislature has a complete, discretion to also control its retrospectivity, to which extent. But the reason is, may I also bring I did that? Your Lordship may just look at the parliamentary debates on this. Of course, I do understand the difference. The external. Another copy of this thing. With the concern was you Lordship will find that at page 741 of that document. I think it's document. Last portion, Your Lordships.
No, that's true.
Yeah, yes.
When the bill was placed on the house, on the floor of the house,
Yes.
then the minister who wanted to place this
Yes.
bill has said that what is the purpose and object,
They did.
underlined this.
Yes.
So there should be a clarity which should come with regard to the without legal authority.
They found it regressive to the entire mining sector because
That
for
is what-
any other law, the violence. Now, Your Lordship, why this happened is, may I take Your Lordship to the common cause judgment? It is a judgment of common cause. Lordship says.
I know that is, again, at that point of time, he must be. So, no, bill always.
That is the judgment where that interpretation was first made. What is 17? Now, Your Lordships, may I just take Your Lordships to para 149. First, Your Lordships, they interpret 21.5 as being compensatory, not in the nature of penalty, even though the 21.5 starts with the
True, he says that he comes under the head penalty, but it is really a recovery of the price of the minerals, which is compensatory.
And 151 talks about that interpretation which came in for the first time after that judgment.
Which?
151, para 150.
No, here he uses the word penalty.
Yes,
penalized a person.
but with your lordships, but I. With your lordships. So basically, your lordships, 21(5) was interpreted here to include that even if you are violating any other legislation like environmental laws or any other legislation, that would also be held as an unlawful act, and therefore you would be liable to compensate. My submission is this: when this explanation comes now, it takes away the complete legal basis of this judgment because it confines it only. Because it confines it strictly, your lordships.
You are hitting that a person who is neither a leaseholder, license holder or nothing, if he extracts.
I'm a leaseholder.
Hmm?
I'm a leaseholder.
So the common cause says that any violation within the
Yes.
lease is also coming under that.
No, your lordships, what now happens is, with the explanation coming in,
Hmm?
they said,
It also includes that.
no, your lordships, it doesn't anymore.
Read.
Your lordships, on and after the date of commencement, your lordships, prior to when this judgment was there, only 21(5) was there. Only 21(5) was there. This explanation wasn't there. On and from the date of commencement of this Mines and Amendment Act, the expression raising, transporting, and causing to raise or transport any mineral without any lawful authority occurring in this section shall mean raising, transporting, causing to raise or transport any mineral by a person without prospecting license, mining lease, or composite license, or in contravention of rules made under section
No,
23.
exploitation license.
Or
Sorry, exploration license is also there.
or in,
That is introduced in 23.
your lordships, yes, further been added, your lordships. Exploration license.
Or in contravention of the rules made under 20.
Section 23C.
See.
Now, your lordships, the allegation against me is for violation under the environmental laws. So they have specifically now taken it out and confined it only to this act or the rules made under section 23C. Obviously, your lordships, it was to do away with the basis of the judgment. Now, your lordships, this is an explanatory and to clarify. The law of, any amendment being prospective is generally not read into these kind of amendments, and to that, your lordships, I would like to show a judgment. 2004 AJC. 2004 AJC. Your lordships, I'm really sorry. my associates somehow have forgotten to get a copy of Lordships. Lordships will kindly. I rely on para 14 to 22.
Erasing judgment.
Lordships. Very good.
Yes.
But I'm also very conscious that your Lordships are going to use, probably ask me to explain that how do you deal with the word on and from. Now, your Lordships, my show cause definitely was after that. It was in 2023. But of course, they are making an allegation of a violation 2019. My submission would be this, that this amendment, of course, why it was on and from? Because your Lordships, in pursuance to the Supreme Court judgment, all the lessees all over the country, especially in Odisha, had already made that payment. And obviously, you had to say, because if it was completely made without having those words on and from, everybody would have come up for a refund. Probably the legislature was quite conscious of that and made it on and from. But it took away the very legal basis of that compensatory liability and destroyed it completely. And your Lordship destroyed it completely. Completely wanted to do away with it because it found it rigorous and regressive, your Lordships, and harmful for the mining sector. That's why I
Oh, I understand.
Yes.
You're borrowing this expression from the
But the reason
minister's speech.
The reason why I'm borrowing your Lordships, I'll cite two more judgments. Of course, two more judgments. Of course, in those two judgments, there was a discussion that when an amendment happens and there is no subsequent legislation, amendment simply, or you do away with a particular legislation, or even if there is a subsequent legislation, but the nature of the subsequent legislation is such that it does not want to at all keep that earlier liability alive, then what happens to a show cause after the amendment? Two judgment to persuade your Lordships. One would be 1911 SEC 795.
1911?
2019-11
Oh.
SEC.
I just thought 1911. I said the Supreme Court was, or SCC was not born.
Now SEC is coming up with the.
That's a Privy Council judgment. They are just borrowing it, nothing more than that.
Now, your Lordship, what happens is here that the Gold Control Act 1968 is completely done away with. Now, your Lordship, may I just refer from para 5? What has been argued by Mr. R. Venkatramani, learned counsel appearing on behalf of the appellant, is that considering that the Gold Control Act itself has been repealed without a saving clause, Section 6 of the General Clauses Act would not apply for the reason that the objective and reason show the Act was sought to be repealed without any savings clause. He relied upon the object and reasons using the expression regressive and the fact that it has given rise to considerable dissatisfaction in the minds of the public as to has caused hardship, harassment to artisans and small self-employed goldsmiths.
His argument was that even if the repealing act does not contain repeal and saving provisions, Section 6 will be robbed in of the General Clauses Act because it is a common law that is always inherent in every legislation. This was repealed by the court. It says that if the object and the intention is very laudable and is very clear that it does not want to save all those actions, then in that event, Section 6 is not that omnibus that it remain an omnipresent in every repealing act.
Yes, and your Lordships, all the show causes which were issued.
That is a different issue.
For the amendment here, were done away. So what your Lordships,
What is the purpose of the explanation or explanatory clauses attached by way of an amendment without disturbing, without repealing, without, I would say, taking out the core fabric of the enabling provisions. It is only to give some kind of the clarity in this regard, nothing more than that.
That's the reason why
That is the purpose. That is the purpose of the explanation.
I absolutely.
Or a note to be appended.
Yes, your Lordship.
In any legislation.
Look at the very wording of this explanation, because what it does, it takes away the complete basis of this judgment.
That is not, it is simply a clarificatory in nature to some extent. It does not mean the other things which would appear from the parent section will also go.
Your Lordships will see.
It does not really substitute the parent section.
Your Lordships will see. Prior to coming of this act, nobody was being charged the entire cost of the oath, because they made a violation of some unconnected.
The difficulty is because on the other day it was there is another, you are referring a judgment, there is another public interest litigation which is there, and there is another litigation where the arguments are advanced, that once the target is given that the production would be in a particular year up to this cubic meter or something like that, then in that event you have to adhere that. It ensures two purposes. First thing is that indiscriminate extraction of the minerals will invite the earlier exhaustion of the entire natural resources, which the government will definitely not, and it may bring a radical ecological imbalance. They do not want. They wanted to ensure that this much. So extraction of more than what is provided in the agreement is also a violation. Is also a violation of the rules and the.
If I had made a violation of the mining plan, I understand it will come within the fold of the act. But your Lordships, this explanation.
This is what they have decided. You have lost up to the revisional authority. So
that's all that they could say. They did not.
What more?
Your Lordships, may I just.
What more?
Your Lordships, may I just two more judgments to 2007-15 SEC 11.
You are indulged in the excessive mining. That is what is there, and you can't take advantage of this. You pay.
Your Lordships. Para 24 and 25, your Lordships.
It reminded me of that particular golden goose story. You wanted to extract the natural minerals or natural resources overnight,
No, Your
then abundant. Then what is the purpose of fixing a particular target every year?
That's
For that, the environmental clearance is given to you.
Your Lordship, let me submit to that. Your Lordship, as far as if I had crossed my mining limit, I can understand, I will.
This is what you have done.
No, Your Lordship.
Excessive.
No, Your Lordship, the violation was on the EC. That means on the
No,
environment.
the environmental clearance says that up every year or up to this much, you can only extract. If you go exceed, then will it not? You are saying that environmental clearance is something devotes the MMDR Act. And if it does not come within the MMDR Act, then this violation cannot be penalized under this Act.
Your Lordship, that's precisely what the explanation.
I understood the entire endeavor and the prelude which you started. You could understand that where you want to reach.
Your Lordship, I am not saying that, Your Lordship, that's exactly what the explanation says that. The explanation now restricts that the 21(5).
No, you're saying that it is raising or a transporting or intending to transport or a violation under Section 23, rules made under Section 23C, which does not really cover all these aspects.
Yes, Your Lordship, they did
I understood what you want to do.
Did away with the judgment. The basis of the judgment is taken away, Your Lordship. The only thing now which remains is this. That whether this show cause, which has been issued after the amendment, will survive or not. And only to that extent I have to show. Your Lordships, admittedly, this has been done away with the
You go there, the show cause has not been decided as yet.
No, it has been decided, Your Lordships, by the divisional authority has.
No. You challenged the show cause notice.
Yes.
Did you give your reply to a show cause?
Everything done.
And then adjudication was done.
Yes, Your Lordship.
Then you started with the show cause. That's why I thought.
That's the basic fact of my case. So that's why I had to.
Yes.
And therefore, Your Lordship, two more judgment which I wanted to show is that if para 24 and 25.
Yes. No, continue.
Your Lordships, if Your Lordships would allow me to.
This is the same principles.
Yes, Your Lordship.
This is the same principles which you are wanting.
Yes.
The Section 6 theory.
Yes.
What is the difficulty?
It's that this explanation does not want to keep that liability with Supreme Court judgment.
Let us see.
That, Your Lordship,
Whether it really disturbs the whole thing in that way.
Your Lordships, it did seek to only now confine it to any violation within the Act.
Yes.
Do away with whatever was said in para 151 of the judgment. The legal basis is gone. The legal basis of that liability is gone.
Yes.
That's all that if the legislation decides that we do not want this liability,
yes,
then I think there was, on the date of the show cause, there was no legal basis, and it does not even make any provision to save anything. It wants to completely do away with that liability, and the reason being that it was regressive and fundamentally detrimental to the mining sector.
Yes.
On that only I rest my case, Your Lordships. And Your Lordships, we did try to make a research. This point is yet to be probably decided anyway.
No,
in fact, Your Lordships, prior to
prior
to this judgment coming, Your Lordships, I had the opportunity to argue the same point. When that explanation was not there, neither the common cause was there. In fact, there was a Calcutta High Court judgment, very old judgment, which supports what the explanation says today. What the explanation says, exactly that is what the Calcutta, and that was the only lone judgment at that time. And I'm saying that, I think somewhere around in 2010 or 11. So today, basically, that's my submission, Your Lordship.
Let us see. Keep it for orders to next Monday.
8th December.
For orders. Who is appearing for the other side?
For this. Regional authority, my lord,
We are the appearing for regional authority, my lord.
Yes. Give your memo of appearance.
Yes, madam.
It's called, what is this next?
Item 8.
May I please your worship?
Up to 130.
The petitioner, my lord, is a registered partnership one, which is a service provider for electrical goods, my lord. It was a successful tender for a tender floated by Indian Oil Corporation. My lord, may kindly see that, my lord, at page 89. That is at annexure 3. He was a successful tender, my lord, at page 29. That is there for a work at Sambalpur, electrical works. Page 29 is the record.
What is your grievance? First
I
you
give up
tell me
my-
what you want to challenge.
Kindly turn to
What is,
Page 39.
what you want from the prayer?
Yes, my lord.
Uh,
Let me submit before the lordship. What has happened? The petitioner, my lord, in the ongoing contract, he raised a bill, my lord, invoice
Yes,
for payment of his running bill.
yes,
That was rejected. Annexure 6 by email saying
yes.
that in the previous tender, where a blacklisting order was passed against you, based on that, we are holding up your payment. Now that order I have annexed before your lordship. In that blacklisting order, there was an order that for 6 months you will be blacklisted. That also that I have
And you
also-
participated, you participated prior to that order of blacklisting.
My lord, what has happened? Let me clarify, my lord. There was in an earlier tender,
Sir, I understood, sir. I understood.
my lord.
Just tell me, when this tender was floated
Yes.
and you were awarded a contract, whether that order of blacklisting was subsisting,
No, my lord, not at that time.
was it passed prior to the participation or during the currency of this contract?
During the currency of this contract.
This contract. Show me there is any
Yes, my lord, kindly
any
don't-
clause which says that it will be withheld or something.
My lord, I have annexed the previous order on which they relied upon. It is at page 43.
Ari, I understand it is for 6 months.
Yes, my lord.
And does it clarify that it will not affect the pending one?
My lord, I'll read out, my lord. The order is very clear, my lord. Accordingly, it has been decided you will be placed under the holiday list of IOCL. Consequently, you will be debarred from entering any contract with the IOCL for a period of 6 months, effective from 25/3/25. This was the order, my
So
lord.
prospective. Not affecting the continuous one or the previous one.
Yes.
That is what I really wanted to understand from you. Who is for IOC?
I am looking for OP 5 and 6. My lord,
I do not know OP 5 and 6. Who are they?
It is who had passed the earlier order, which is at annexure 7, which is now being relied upon OP number 224 to stop my payment.
So you are representing IOC.
My lord, I also OP 5 and 6, not my lord.
But there are different divisions.
Different divisions.
The Paradigm division. part
Notice,
of the-
notice to 124.
You are for refining.
Notice.
My lord, I have instruction to appeal, my lord.
Why?
Even 6.
You are for
Why not 124? Why not 1?
My lord, for the different division, where now I am.
Why not 1?
One is the chairman, my lord.
So will you not?
As your lordship please.
1 to 4 you notice.
My lord, there are two matters. My lord, there is an interim prayer I have made.
In this, it cannot be. They have simply denied the payment. Let them come. No difficulty.
Now-
What interim?
The words of financial ruin.
No. Just
There are
wait.
two matters, my
We
lord.
have given a short notice. Same thing.
Second matter also, my lord.
Same thing.
Yes.
A different contract.
Yes, but I must point out one thing, my lord. It is not totally the same. The second contract was entered into at West Bengal. But why I have invoked it? Because under Article 226(2), they have relied on this same order to block that contract. So part of cause of action arises
Is
within
it?
the jurisdiction of this order.
My goodness.
I must point out, my lord.
I must express. Is it constitute a cause of action?
Yes, my lord. In the second case, I will give a judgment, my lord.
Kusum in guts, you
No,
give me. Kusum in guts, you give me. You alchemist judgment, you give me.
One more judgment, my lord.
Give me that.
The third judgment, my lord, just
That it is a part of the cause of action. He relies upon a particular judgment, and therefore it becomes a part of the contract or the cause of action. I have to.
my lord.
I have to then.
There is a plethora of judgments. I have out of.
Let me. That's my ignorance. That's my ignorance.
No,
A person should not remain ignorant throughout his life. he should understand, yes.
Lottery. This is lottery, GST.
Pardon, my lord?
Lottery.
No, I am not.
This is lottery
The fact.
filtered in.
I am on the principle of law, my lord, because whether the Sikkim High Court would have entertained territorial jurisdiction.
Sir, the lottery conducted by the Sikkim, state of Sikkim through Pan India. And if any part of the cause of action concerning the lottery happens in particular state, I understand if part of the cause of action has arisen. Here is a case where you are talking about that there was an earlier order which is passed, and this order simply contains a reference of that order, and foundation is laid thereupon. Does it mean that it is a part of the cause of action?
Because it is the order.
Sir, order is passed somewhere else, the order is communicated somewhere else, order has been done. What are you talking? Everything has happened in Calcutta. That is what I'm saying.
Because the order being relied upon, that order was passed within the jurisdiction of this honorable court.
Sir, that is what I am asking. Does it form a part of the cause of action?
Yes, my lord.
I am asking the order is not passed here.
No, the order was not passed here. The order was there.
So he simply relied upon this order which is passed here as the foundation or a basis. Does it constitute a cause of action? I'm just asking. Show us. I have not got any judgment as of now that it can constitute a cause of action.
My lord, on the facts of this case,
it's very interesting because this court will reject or say that district court rejects a particular petition relying on a judgment of the Supreme Court. And then you will say the part of the cause of action will be at the Delhi. So I can go and challenge that order in the Delhi.
No, my lord, they are the
very interesting because that's a reliance. It is merely a reliance upon a judgment that I do not want to take a different view.
My lord, where that judgment is different, my lord, what
are you talking about?
Passes an order, and if it is outside the state appellate authority there.
Sorry. I don't think so.
That where the order of the original authority is passed, there it will lie.
No, there are. It is not a very, very inflexible rule what you are talking about. It is not an inflexible rule. This is originating right from early. I know the first origin is of 1960s judgment. The early part there it says that if the appellate authority is sitting, the situs of the appellate authority is at a different place than the original authority, then what the jurisdiction would mean and where the challenge can be made. I am conscious of that. It all depends upon the nature of the jurisdiction or the powers which is exercised by an authority. I am not, but what you are proposing is something very new to me. That's why I just wanted to enlighten myself. Nothing, not denied. This
because, my lord,
since this has been filed, keep the maintainability of this writ petition open, and no notice is required.
No notice, my lord.
First you fix it.
15th December.
May I say 1 day after that?
And in this matter, pendency will not prevent the authorities in proceeding. Which one?
Item 36. 36 million.
Yes.
Still in the other matter. Miller
Let us see, sir, not, we will not disturb our roster. Just wait. Let us see.
Item 48, please put 48.
It's similar matter. Baleshwar alloys. Pending before the judgment passed by this honorable court was challenged before the honorable apex court. There the honorable court has granted stay and the matter has been posted to 6th of January 2026.
What is the point?
But that interpretation of 10(2)(c), that is the exception carved out in the MMDR Act by virtue of amendment, where the because if your lordship 10(1)(a), that takes away the rights of the pending applications.
Could I open,
MMDR.
if your lordships, if my learned friend doesn't mind, I'll deal with his aspect. I knew that the state was going to try and mention Baleshwar alloys. I will clarify to your lordship how we are different from Baleshwar alloys. I will tell your lordship also what has transpired in Baleshwar
No,
alloys.
only thing is that whether the point
No,
which
the point is,
which is there,
straight away.
which
The
is there.
As I told your lordship the other day, my lord, my learned friend is in error in saying that the issue is the virus before the court. It's not that at all.
It's not the
The virus issue
It's
is
not the
before
virus.
the Supreme Court, yes, but in a matter of XSL mining. That's a totally different aspect. I am therefore not even, my lord, on the virus before the lordships. As I told you, lordship, the last occasion, my lord, I am only on discrimination. The reason I am different from Baleshwar alloys is, my lord, if I show your lordship the law, there was a cut-off date of 11th January 2017, which was, my lord, no, your lordship will just bear that one date in mind. There was a cut-off date. Did you submit all your compliances before 11 January 2017 or not? Is the issue. In Baleshwar alloys, there was, my lord, one issue of compliance, which was the submission of a bank guarantee under the rules I'll show your lordship. That was not given by Baleshwar alloys. Instead, they came to court, got a stay order initially, and then, my lord, their lordships, as my lord Chief Justice Vineet Saran, as he then was, my lord, their lordships, that bench held that, my lord, apart from the virus, which of course they didn't touch because of SL mining, they said on grounds of, my lord, legitimate expectation and promissory estoppel, because, my lord, they had paid all the monies, etc., everything, and the period was too short because they got a grant on 9th January. They were supposed to give a bank guarantee by 11th January. The grant did not mention how much is the bank guarantee. So on the 10th, they came to court and said, look, we are completely helpless in 48 hours. We can't comply. So please grant us a stay. The Honorable Court, you know, granted a stay, eventually held in their favor. State went in appeal. That matter, my lord, on the very day, last Monday, in fact, when I was before your lordship, my lord, the next day the matter came up in Supreme Court before a bench of Justice Maheshwari, my lord, and Justice Bishnoi. They heard the matter. An order has now been passed that, my lord, there are contrary views being expressed both by the state and by the applicant as to what is the real position. The state said that from 2009, when the, my lord, original grant was made, that there were several non-compliances. Baleshwar alloys said all compliances had been made, except the fact that, my lord, this last mile, as it were, of non-compliance was because the state in its second grant, there was a second grant order, my lord. In our case, A, there is no second grant order. B, in our case, every single compliance, including this bank guarantee, etc., everything is in place. C, more importantly, my lord, identical cases of other lessees who are on all fours, identically situated as me, who, my lord, go and give them on the 10th evening all their compliances. Their leases are executed on 11th. I'm left out. So that is my very short point.
So mean the crux of your matter is whether you can be discriminated
That's-
with
That's it.
another
So, but-
similarly circumstanced.
The pictures. I am in a company called Sri Metallics, which
Where
I
is the
showed you.
difficulty?
Baleswar alloy is
The
completely out.
implication of 10C or something, this does not arise here because if the compliance is all.
My learned friend can't take the easy route out by saying, await Baleswar alloys, because this is, I knew that the state will come up with this argument first thing, but that's the easy way out.
There is another amendment, that is 8.4. 8.4 of the MC rules that made it mandatory that the lease deed has to be on compliance. The lease deed has to be executed on the cutoff date. Now the difficulty is the day the petitioner submitted all his documents and records on the very last day. Now on the date, so lease deed has not been executed. So your lordship will also test the effect of 8.4, though it is repealed in 2020-21, but it stood as it is on the date when the documents were made, compliances were made, and the provision remained in force until 2021. So that effect also your lordship.
Sure, no difficulty. I'll show your lordship. I don't think that will come into picture at all, because all I am asking your lordship to consider, my learned friend is right, that because all our grants came on the 9th, this is a separate grant. We got a forest clearance on the 9th. So we applied on the 10th, as did Sri Metallic applied on the 10th. How do you execute their lease deed on the 11th? You say I have enough time to do it, but you don't have time for me. And apparently, my lord, out of 18 others who were similarly situated, 16 were gotten executed. So you kept one person out, my lord, who obviously...
Where are those facts?
Straight away. My lord, first, let me therefore show your lordship the law, so that your lordship will understand, my lord, what conspectuses of facts, my lord, we are operating in. I won't take more than, my lord, 20-25 minutes at the highest, my lord. Please, my lord, I culled out all the law, my lord, in one place for your lordship's easy conspectus, so that your lordship don't have to then, my lord, give this. Your lordships don't have to, my lord, struggle with the acts unnecessarily. This section 10, my lord, may I just tell your lordship, my lord, the MMDR Act 1957, earlier, my lord, grant was the route. 2015, Parliament in its wisdom, my lord, rightly so in my opinion, my lord, and with great respect, I'm sure your lordship will concur. And my lord, all the courts
wanted an auction concept.
Went by the auction funds. So the auction regime came in. Once the auction regime came in, my lord, this were the amendments which were made in the auction regime. Your lordship will see kindly, my lord, section 10A, the rights of existing concession holders and applicants after this amendment. All applications received prior to the date of commencement of the Mines and Minerals Act 2015, that's the amendment, shall become ineligible. So that's the first principle.
All is making every application.
Probably carrying coal to Newcastle because the lordships day in day out must be dealing with these issues, my lord. So I'm very sorry, my lord, if I appear, my lord, to be over enthusiastic. My lord, clause 2, my lord, without prejudice to the subsection 1, the following shall remain eligible. So an exception is carved out on and from the date of commencement of the Mines and Minerals Development Act 15, my lord. Now, your lordships need not, my lord, trouble with A, with B, because A is with the 11A, we are not concerned with 11 capital A, my lord. B is where, my lord, for prospecting and reconnaissance, my lord, we are not concerned with that. C is where we are concerned. So next page, my lord. Your lordship will kindly see. Therefore, without prejudice to subsection 1, the following shall remain eligible. C, where the central government, C, my lord, your lordship have the next page, C. Where the central government has communicated previous approval as required under subsection 1 of section 5 for grant of a mining lease, that's, my lord, the first limb. Or if a letter of intent by whatever name called, could be a grant, could be a LOI, could be anything, my lord, has been issued by the state government to grant a mining lease, this is the second postulate. So first central government, second state government. Before the commencement of the 2015 Act, the mining lease shall be granted. So, my lord, is mandatory, shall be granted, subject to fulfillment of the conditions of the previous approval or of the letter of intent within a period of 2 years from the date of commencement of the said Act. So, my lord, they went in appeal in Baleswar alloys saying, my lord, that one of the conditions was not fulfilled. So, therefore, how could the High Court, my lord, on the basis of legitimate expectation or promissory estoppel, grant them this? That is a short point. Provided that in respect of any mineral specified in the first schedule, no prospecting license or mining lease shall be granted under clause B. My lord, again, we are not concerned because we are not in this aspect, my lord, without previous approval. Now, my lord, your lordship may thereafter just kindly skip to page 4 because that's the cutoff date comes in there in the rules. The mineral other than atomic and hydrocarbons energy minerals concession rules 2016. So it's the mineral rules basically in short, my lord, of 2016. Rule 8. Rights under the provision of clause C of subclause 2 of section 10A. I just read that to your lordship. Section 10A 2C, my lord. The applicant in whose favor the state government has issued a letter of intent by whatever name called in writing before January 12, 2015 for grant of a mining lease for mineral not specified in the first schedule of the act, or I omitted something. The Amendment Act came into being on January 12, 2015. That's the date your lordship will kindly bear in mind. So 2 years from then, my lord, therefore January 11th, 2017. That's the cutoff date. The central government has communicated the previous approval in writing before January 12, 2015 under subsection 1. You know, I don't need to trouble your lordship with B or clause 2. In fact, my lord, I need to straight away take a lordship, as my learned friend rightly pointed out, to 8.4 because that's the critical part. Where an order, that's at page 5, my lord, where an order for grant of mining lease has been issued under subrule 2, the mining lease shall be executed with the applicant in the format specified in Schedule 7 and registered on or before 11 January 17, failing which the right of such applicant under clause C of subsection 2 of 10A for grant of a mining lease shall be forfeited. And in such cases, it would not be mandatory for the state government to issue any order in this regard. So, my lord, sunset of, my lord, absolute irrevocable sunset, as it were, of 11 January 2017 was set in place by this, my lord.
Automatic forfeiture.
Automatic forfeiture thereafter, no right therefore endures, my lord. And this, my lord, is what has been challenged in the SL mining, where, my lord, they say that what is the rationale for this sort of, my lord, carved in stone cutoff period, as it were, where there is absolutely, my lord, no possibility of any kind of latitude, where all kinds of, my lord, reasons may obtain, as your lordship I will see, my lord, even in my case, where for years on together, my lord, you struggle with both EC, which is, my lord, environment clearance, as well as with FC, which is forest clearance. Both FC and EC, my lord, can take, with the greatest respect, my lord, the ease of doing business in India, my lord, unfortunately, is not so easy. Many of these, my lord, aspects take many years, and as I showed your lordship in my case, even though my grant is of 2008 original grant, my lord, it actually took me, my lord, 9 years to clear my EC as well as my FC. That's how long it is taken. Because of myriad number of, my lord, A, steps that you have to take, B, my lord, the goalposts keep shifting. Every time, my lord, you come close to all compliances, the amendments come, the law changes. Suddenly, my lord, they say that no, this was the past regime, now you will go by a new regime. So therefore, many of these claimants, my lord, unfortunately have had to struggle with these issues. But even then, once you have, my lord, surmounted all that and got all your clearances, my lord, and what the law says, subject to fulfillment of the conditions. So if I have then fulfilled all the conditions, however onerous they may have been, then, my lord, would you then still oust me? When you have not ousted others who are exactly similarly placed. And how they are similarly placed, my lord, let me first show your lordship that, because that is the nub of the matter, my lord. Would your lordship just kindly see my rejoinder, my lord, because that's where, my lord, I got the original, when I filed the writ petition, my lord, I in fact didn't have that fact with me. So the writ petition originally was filed, my lord, obviously on the basis of the virus, etc., which everybody else was filing. But if your lordship just kindly see my rejoinder.
Which one?
There is the rejoinder that I filed to the state's affidavit, my lord. Just you have to help. Just flag it, please. You have flag? Yes.
Page 122. Just click.
No, rejoinder. Rejoinder.
122.
General to counter affidavit of opposite part number 3.
My lord, your lordship is absolutely right, sir. I'm grateful to my lord. Absolutely. I'm so grateful. In this rejoinder, my lord,
Yes.
what I pointed out to your lordship was, my lord, kindly see at internal page 33. Your lordship will see, my lord, this is in the case of this company called Shri Metallics. Your lordship will find at page 34, my lord, column number 6 at copy 2 at the bottom.
Yes.
Shri Metallics. This is the company. My lord, this has been addressed by, my lord, the conservator of forests. So this is a forest clearance to the principal secretary, my lord, Forest and Environment Department in the government of Orissa. And the date is critical, 10th January 2017. 1 day before, my lord, the sunset, that irrevocable sunset. I am directed to refer to, my lord, state government so-and-so dated, my lord, on the day, what date is this? This is 2016, I think, my lord, if I'm not mistaken.
9/12/2016.
9/12/2016.
Yes.
On the subject, my lord, mentioned above, seeking prior approval of the Ministry of so-and-so, my lord, the MODF that is, and to say that proposal has been granted by
No, has been examined by the regional empowered committee. constituted-
examined by the regional so-and-so committee constituted by the central government under section 5.
And after careful examination
I'm
of the
grateful.
proposal,
I'm
seeking
grateful.
prior approval and on the basis of the recommendations
I'm so sorry, Lord, you're-
of the regional power, that is on 16, approval, the such and such
That's right.
is hereby granted under section 2(3),
That's
Roman
right.
3 of the Forest Conservation Act
That's in favor of
concerning 35.774 hectares of
I'm-
forest land
in
in favor of Sri Metallics Limited.
for iron ore and manganese and so on, so my lord. So, no, therefore, your lordship can then NPV, the state government shall charge NPV. So, NPV in that case, my lord, in fact, had still not been ascertained. Kindly see the 1(2)(a). After 1, legal status shall remain unchanged. 2(a), the state government shall charge the NPV of the entire forest land. So, this is on the 10th of January. This is the situation. This is, my lord. So 10th evening, my lord, they comply with all this. They file.
What about Roman 3?
Roman 3, my lord, is at the time of payment of the NPV at the then prevailing rate, the user agency shall furnish an undertaking to pay the additional amount of NPV. And they must have given this undertaking.
Yes.
That's only an affidavit, an undertaking by way of affidavit. So all this they must have, my lord, complied with. There's no question. I'm not denying that. But the good point is, my lord, that they were lucky. They managed to comply. And they got their lease executed, my lord, on the 11th. Your lordship will kindly find, my lord, that lease again I got by way of my additional affidavit that I have, my lord, filed on the 11th of September. If your lordships my lord, has
11 or 15?
11th of September, my lord, 2025.
Oh, there is an endorsement of 15 September.
I'm grateful, my lord, if your lordships. I'm sorry.
There's a 3-4 page additional affidavit.
Your date is 11, but it is stamped in this registry is 15 September.
I'm sorry. It could well
Okay,
be.
this is affirmed on 11th, whatever, is affirmed on 11th, but actually received by the
Registry-
department on 15th.
My lord, I'm
Registry.
grateful if your lordship.
Yes. No,
Your
no.
lordship there will find, my lord, if your lordships kindly see. So the 10th your lordship saw was the
Yes, forest clearance.
page 45, my lord. Page 45.
Internal page 45.
Yes, my lord. That's the lease deed. And it's this deed dated the 11th of day of January 2017. So 10th they get a FC. Next page, my lord, also is there, my lord. This deed made the 11th. So last day, which is the cutoff date, they've happily executed this. Good luck to them. So I am exactly similarly placed, my lord. I have complied with nobody's case that anything was outstanding. Only thing they say we received it is too late. 10th was too late. But you got
Where do I get that correspondence that they say that it is too late in a day now?
They counter. Straight. That's the only defense, my lord. There's no other defense. The lordship will kindly see the counter affidavit of, my lord, respond number 3, which is the
Counter affidavit is appearing in page 118.
I'm grateful, my lord.
So
Deeply grateful to your lordship.
this is opposite party number 2.
Number 3, my lord. 2 is MOEF, my lord.
Okay.
MOEF is
Number
only
3,
stated the
number
statutory
3
position.
counter.
Number 3,
Dagotu.
my lord, Act, your lordship will find
Page.
page 94 running page.
Huh?
94.
94.
Page 94 running page, my lord, your lordship. What is this? Para 12.
Yes.
And there, my lord, I'm requesting your lordship to kindly go to para 12 straight away. my lord.
Why it is not included here?
Page 105, my lord, your lordship have
Oh,
a
it is here.
page
94.
105. Running page 105.
Correct. Yeah.
Your lordship see that, my lord, that the petitioner.
105 paragraph.
I'm sorry, my lord. My lord, I think it's 4.12 is at page.
No, you can give an internal page
Page
number.
99, internal page 6.
6.
Internal page 6. And paragraph number 4.12.
Huh?
4.12, my lord.
Okay.
Paragraph 4.12.
Yes.
My lord, that the petitioner submitted the compliance of the letter of intent before OP3 on 10/1/17, late afternoon, as per Rule 8.1 of the rules, to be considered for grant of lease under 8.2, but the time was too short to process the compliance letter of the petitioner for grant on or before 11/1/17. Hence, the petitioner failed to submit full compliance of the letter of intent as per 8.1, well before in time for grant of the lease under section 8.2 of the said rules on or before 11/1/17.
Yes.
My lord, thereafter, your lordship again will find at 4.14, my lord, the full compliance of the letter of intent has not been made by the petitioner to the state government in time. This is incorrect, my lord, clearly, because there is no particulars, my lord, of what full compliance, further full compliance did you want. So this is just a cut paste from some Baleswar or whichever other affidavit. This is not correct. For grant of mining lease, as a result, the grant of lease was not considered by the state government due to non-compliance of the letter of intent, that is, terms and conditions by the petitioner in time, the right of the petitioner for grant. Again, this is completely irrelevant. So they don't specify what condition is not met because they can't. Everything was actually factually met. So, therefore, the only thing is correct. It was too late, but it was too late for everybody else as well. You happily went and executed for them and not for me. And everybody, was, your lordship saw, in fact, my FC was 9th. Sri Metallics was 10th.
Where is your FC?
My FC, I'll give your lordship straight away, my lord. Your lordship, see my writ petition kindly, my lord. It's actually the 6th of December. I'm sorry, my lord. It's not 9th. Huh? Oh, my FC, yeah. So it's the 9th of January. Your lordship will find that at page 67, my lord. So I, in fact, got my FC a day earlier than them. Your lordship find 9 January, exactly is the
Is
state.
here by the same language.
That's same language. These are templates, my lord. And next page, page 69, kindly see it is my challan for the NPV I've put in. 4.2 crores was asked of me. I paid the 4.2 crores on the 10th, that's the challan on the 10th. And I have requested them again at page 70.
Yes.
For my compliances, my lord, I have said compliance report with regard to grant of the lease by them. So the grant, my lord, so therefore, as per the act, there is a grant in my favor. As per the act, my lord, I have got FC without which they will not give you a lease, my lord.
Yes.
And as per the act, there is full compliance, therefore. I'm exactly similarly situated as Milord Sri Metallic for one. And I'm given to understand there were Milord 8, that Milord RTI still has not come back to me. I applied that how many people, Milord, have you executed within the period of 9th and 11th? We know, Milord, in Baleswar Alloys it's come out that there were 18 such people who were similarly situated. For 16 happily placed people, Milord, they went ahead and executed. And they kept us up. So, Milord, it's a very short point with great respect. I don't think I need to trouble your lordship with Milord, all the other conspectors of facts. The fact is they cannot point out that there is any non-compliance. They are saying it was too late for us to do this, but it was not too late for others. Why is it too late for me? As simple as that. there's anything else, my lord, I need to satisfy the
Yes.
lordship, I am here, my lord. Thank you, my lord. Very grateful to your lordship. You have rejoined me, my lord, I'll need to note down.
Article 14.
That's it. Simple
Yes.
discrimination case.
Mr. Das,
Article 14,
straight away.
but
That's the, I think, the substratum of their argument.
Article 14, there is no dispute. Article 14, equality before law. But all fundamental rights are subject to reasonable restrictions provided
Oh.
under the law.
Restrictions
Now, my
in,
lord-
on the parameter of discrimination.
But here the restriction, but if your lordship otherwise knows that the rights of the parties stand crystallized as per the law on the date of filing of the writ application, my lord. Now, what was the law prevailing on the date of the filing of the writ application? Now, my lord, if your lordship will look at 10(2)(c), 10(2)(c) though carves out an exception, but at the same time, it adds a liability under 8(4), my lord.
No,
8(4).
understandable. Are they three metallics having the same kind of a problem with him? Because his case is that I stand on a same pedestal that of a three metallic. And if I stood on a same pedestal, how can I be denied a right which you have already extended to three metallic?
But my lord, it is a fact that there is no execution of lease deed as on the cutoff date, my lord.
I'm asking whether three metallic you could do it if the clearance was done on 10th. Then he could not be said to have complied all the conditions which are required before 10th. If he has submitted on 10th, you executed on 11th. If he submitted on 10th, why you can't execute it on 11th? And can you take a shelter that it is too late in a day or the time is too short to take all such those? These are all the formats. I think the lease contains all these standard terms and conditions applicable uniformly to all. There cannot be any special criteria for this, except the description of the property or the land, mining land, or demise. May I use this demise land? Nothing more than that. That's the only variation. And discrimination is always viewed very seriously. If you can put them that these three metallic and they are unequal, I can definitely say that equality clause does not come amongst the unequals. No doubt. Not a slightest hesitation in our mind. But if they stand on a same footing, similarly circumstanced persons, identical situations, then why? You acted, you showed harit, and you buried them.
But my lord, the fact lies, no lease has been executed on the land.
True, that is what their concern is this, that why I'm not a stepson or a stepbrotherly person that you should treat me in this way. I'm equally important to you. Then why you will give me a different treatment than the others? That's the only point. You need not have to go into the nuances of all other situations, except this, because you have not denied that the three metallics stands on a something different or differently. Can't. And for one, it is a sufficient time, and for one, it is a shortage of time.
My lord,
In fact,
I'm stuck with my own judgments. I am definitely borrowed from the Supreme Court judgments on the discrimination.
yeah, my lord, just my learned friend permits me 30 seconds, Lord. I'm personally aware of this fact, Lord. Because all the states, Karnataka, Odisha, Jharkhand, you are all aware, my lord, of this 11 deadline. So the mining department, my lord, burnt the midnight oil. They kept these leases ready, my lord. Absolutely. They knew that they had to finish this before the 11th, my lord. So they had some 25, 30, 40, they knew all the applications they were there, my lord. So they kept all the leases absolutely ready. All it needed, my lord, was just to put in, as your lordship, my lord, so pithily put it, my lord, put the lease numbers and put in the name, the nomenclature of the parties. So they were fully ready. They knew, my lord, that there was a deadline to meet. So every state knew they had to meet that deadline. I know this for, I have other clients, my lord, who had it done. So therefore, my lord, this is only a case of, my lord, somebody who, with great respect, didn't approach the power that we, my lord, in the proper fashion.
the question is, in the writ petition, they had challenged that 8-4 initially.
No, now they can, under Order 23, Rule 1, it is within their domain to abandon any of the claim and to restrict on one. They can. They have abandoned all the claim. Simply they are banking upon this aspect that how can you discriminate him?
If they abandon that prayer for 8-3, then your lordship may kindly see the consequences. The consequences is that
Consequences is provided in 8C.
yes,
Whether those consequences can be attracted,
it is automatic. Your lordship may kindly
again, I'm saying automatic is the deadline. You have put a deadline.
but the deadline
That is on 11th of January 2017.
that 11 January, that deadline, if your lordship may kindly see the language of the
It is inflexible, no doubt about it.
yes.
But what about the violation?
Well, it exactly cannot
It
be
gives
said as a violation.
then in other words, it will give a premium to an illegality or a violation of a fundamental right by an authority.
No, this is stay.
As the deadline has.
No, today there is a stay, my lord. It's a granted interim stay. And said there is no bar. Your lordship's first order was stay.
Even then, if there is no stay, there is no stay, let us proceed on that basis.
Well, even accepting the contentions raised by my learned senior, well, it's the delay for production of the documents.
Where is your case? In the counter, you have not said that this document was wanting. This was not submitted by him. This is what there is a shortfall. You have not said anything. You simply said that you have complied all the conditions which are required, but not in time, means the time is too short to process your application for the purpose of execution of a lease deed. Meaning thereby that they have approached you on 10th. 11th was that particular, I would say, the date, the magic date. And therefore, we could have understood that somebody has come at the last minute. And then you say it's too short, we can't. But it is completely different that the others have also approached in the same time when they have approached, and you have said that it's too short for him. Fine, no difficulty. You are within time. How can it? I can understand it that if they come, say, around 5th of January, somebody has come on 4th of January, somebody has come on 6th of January. You had the enough 5-6 days or a 7 days buffer time. That's the time is there. You could do it. But so far as Sri Metallic is concerned, they have obtained the forest clearance on 10th. So there cannot be any compliance before 10th. Because this is one of the condition precedent for this. and then you executed on 11th, whereas they came on 10th. You said time is too short. I can't do it.
You cannot improve your own case. What
The
you have
question of
resolved
equality, I-
after amendment. Can you improve your own case? You can't.
but on the question of
We're not going to that.
that
We're
8-4,
not going to that.
but 8-4 has to be interpreted.
Sir, you have interpreted
In I would say, in a beneficial manner, so far as the another person is concerned.
But my lord,
And
even though,
manner so far as the-
my lord, even though it is interpreted in a different manner, as stated by my lord senior,
Having suspended
but-
the lease.
but the lease,
Forfeited the lease.
but the
and
lease,
put The lease in abeyance.
but
Look, the Supreme Court might have interpreted in a different way. You have interpreted in this way. So I'm keeping your lease in abeyance. It will not come into effect.
but the fact is the
Even if
lease,
suspended, I can understand. No
Well,
problem.
but the fact is the lease was executed on 11-1.
So why you could
But-
not,
but
why
in-
you could not execute the lease on 11-1? That's the question, sir. I know your problem. Question is not other thing. Other thing is why you could not. If you can do it for one, you could have done for another. Yes.
My lord, may I, Lordship, may look at 8-4 once again, my lord. 8-4. 8-4, my lord, where an order for grant of mining lease has been issued under sub-rule 2. The mining lease shall be executed with the applicant in the format specified in Schedule 7 and registered on or before 11 January 2017. Failing which, the right of such an applicant under clause C of subsection 2 of section 10A for grant of
C is
stand forfeited.
That is what is.
And in such cases, it would not be mandatory for the state government to issue any order in this regard.
For them automatic lapsing.
Lapsing.
Understand that. The question is how.
And in case of interpretation of the identical provision akin to 10A2C, 10A2B, in case of Larsen Toubro, this honorable court has dismissed that writ application, which is again the subject matter pending before the honorable court. Larsen Toubro matter.
Sir, we will uphold the provision of this new rate. We will say that they are taking shelter under that particular property. Yes, 11th was the last. But why you did not execute? Because they have complied all this.
Lordship have taken this.
You can't improve your case.
Yes.
You have done it in the country. And now you realize when you simply put something only into a format without any new application of mind, what is the effect? You understood, do you understand what I mean?
Yes, sir.
That's the point. Now tell me what to do. Because there is a now the question is the deadline which is going to.
No, that the state can't take advantage of its own wrong. That your lordships are well, your lordships lay down the law.
Understood. The lease is directed to be executed, it has to be executed or will remain operating presently. From an perspective effect.
May I just show your lordship the interim order that was passed? Your lordship don't mind, no?
So the difficulties. Because I have started with section 5 of the Transfer of Property Act as well. The transfer can be effected either in present or in the future. What?
Would your lordship just see the order of 16th of January 2017? That's the interim order. Passed by your lordships. May I read that? The submission of Mr. So-and-so for the petitioners is that the petitioner had applied for grant of mining lease, which was duly approved by the central government under 5(1) of the MMDR Act on 29/9/2003. The application, however, was kept pending, and in the meantime, the Act was amended and certain provisions have been inserted by the Act of 15 with effect from 12/1/2015. Under the new provision of Section 10A, lease deed is to be granted within a period of 2 years from the date of the amendment of the Act, that is with effect from 12/1/15. Besides, several prayers which have been made, the grievance of the petitioner at this stage is with regard to the provisions of 8(4) of the rules, which provide that in case the mining lease is not executed on or before 11/1/17, the rights of the applicant shall be forfeited. The submission of the learned counsel of the petitioner is that because of a lapse on the part of the opposite parties, the mining lease has not been granted, for which the petitioners cannot be made to suffer. The petitioners further contend the provisions of sub-rule 4 of 8, Rule 8 is contrary to the provisions of 10A2C of the Act, and the same cannot be sustained in the eyes of law. That's the Vairis. In our view, the matter requires consideration. Mr. So-and-so boasts on behalf of the so-and-so will not pray, grant, etc. Considering the facts and circumstances of the case and keeping in view that submissions made by the learned counsel of the parties as an interim measure, it is directed that the provisions of Rule 8(4) of the rules shall not be made applicable in the case of the petitioners till the next date of hearing, and that interim order has continued till date. So 8(4) has been kept in abeyance as far as I am concerned.
Vis-a-vis you is concerned.
And this has not been vacated.
Now, what will be the regime, if we direct the execution of the lease,
And
That's, I understand, I'm just
mandamus,
being an intellect.
of course, my lord.
Mandamus to execute the lease. The lease will take effect from today,
It will. That it will.
and then the 8(4), it talks about the last forfeiture on the expiry of 11th of January.
Because of your lordship stay order, my lord, that 8(4) is kept in abeyance. And today, in any case, there's no 8(4). Today, there is no 8(4) on the rule book anyway. It's gone. They realized themselves, my lord, that this was an untenable provision. So the 8(4) is gone in any case today. So today, there is in any case no violation of 8(4). That's been, my lord, abrogated. So we are therefore looking at a fact situation. That's right. That's right. It's been deleted.
Omitted, yes.
In 21, my lord, it's been deleted.
In
So
21.
today, my lord, therefore there was an abeyance of 8(4) by your lordship's constitutional court's order, my lord. Therefore, there is no difficulty at all. There's no bar, there's no fetter at all. He can't, my lord, hark back to.
There's nothing.
Only.
This forfeiture.
That's right.
Is gone now.
He's gone. That's right.
But his rights, as he claims.
No, no,
stand-
that is what we have to decide on the facts. So I was just thinking about the relief.
Yes, my lord. Yes.
There is what relief now. After such a long period, I do not know why it remained pending for such a long.
Yeah, but it's
And my lord,
Answer is very difficult.
affidavits took time, my lord.
Whatever, yes, is not a.
May I be honest, my lord, your lordship's alacrity at disposal is, my lord, is remarkable. That's not always been the case, my lord. I think with respect, my lord.
Holding the relief. Earlier, original relief becomes inapplicable. I was just thinking what to do with the city, the forfeiture continues. Now it has also gone. But it means that the forfeiture clause has been.
the lordship may kindly see, the forfeiture clause has been taken away. Yes. In view of this amendment that was brought on 2nd November 2021. Now, your lordship may kindly see Rule 4. In the said rules, Rule 5, 7, and 8 shall be omitted. Now, my lord, this omission takes place only in 2021.
Oh, I understand.
That is one. Number two, there is not a saving clause in this amendment rule. Now, in view of the provisions of the General Clauses Act,
Section 6, huh?
the rights and the liabilities, both. my lord.
Function of Section 6 of the General Clauses Act, that it is not the universal rule that the section would be ingrained or inherent in the
Yes.
process. But I am not conscious.
Abeyance by the court order, my lord. It's an abeyance by kept. Yeah.
One can take note of the subsequent event. Judicially recognized facts. And it is a document which cannot be denied.
No, we are not, because from the very beginning, I said that this rule was repealed, but the rights of the parties stands crystallized from the date, and as per the law, on the date of,
That I understand.
and the effect of repeal also, the repealing act, since it does not have any saving clause. So as per 6, both rights and liabilities are. That is. I leave it to your lordship, my lordship.
Unfortunately, the same problem arose in some other state act. But ultimately, the court could not decide it and simply close down the door for another revenue to come.
And in Baleswar alloys, this honorable court took note of that Bhusan Power and Steel, where this 10A2C read with 8.4 was taken note of. Now, this Baleswar alloys case is also pending, and in case of Larsen Tubro, the identical provision, that is 10A2B, that is in respect of prospecting license and reconnaissance license, that is also pending before the Supreme Court. That is all what I wanted to bring it to my lords. And apart from that, the provisions and rights.
Because they want to gather all the apologies. Here for the parties.
Welfare. That is.
Say. We will take the judicial notice of this one.
Yes. Lots of
That has now been subsequently repeated. And we will also take into consideration the issue order which is already said.
My lord, may kindly also take note of my argument with respect to the provisions of
Sake of an argument.
because I have both General Clauses Act and 8 and so.
This is rely on that judgment of the Supreme Court where it doesn't account the others. The council appearing for the private getting it. Are you the same point? The both in relation to a work on them. Something information of taxes were there. Is keep it for orders on this.
Would your lordships, desire us to file a written note in 2 days, just a 2-page note, just to.
This is a small matter.
Very short.
I think we did not elaborately.
Nothing, other facts are not important.
The nitty-gritty of the feelings and all everything. Is there.
Short and simple. I'm very grateful to my lord for giving us this.
Some judgment will definitely rely on a ground of discretion.
The lordship also
We'll give a compilation.
Power and
Your lordship assistance.
lordship by
A compilation. 2 days, we'll file a compilation of judgments to your lordship assistance. I'm sure your lordships have the whole thing on your database.
Also, it is a case of
Reflected in order dated 24/4/2018. This is number 17260/2017. Computer page 14.
yes.
Seems. Nothing. There was no occasion to argue that. Absolutely. It was only on promissory estoppel and legitimate expectation. We'll hand over a copy of the Balekshwar judgment also for your lordship's consideration. I'll give a copy. Give a copy.
That copy is there.
So
Is there.
is there. In fact, I was watching the proceedings. I was not briefed on the matter, but I was watching the proceedings for Justice Maheshwari. But I have no doubt that your lordship's order will be upheld. The prima facie, I could see that the court was inclined. That is, you can't shut the door on the face of a party which could not do something because you did not give him the chance to do it. They didn't tell them what was the amount of the bank guarantee. How would you give a bank guarantee if I am not told how much is the bank guarantee? I can't.
And they kept writing to the state government 2 days consecutively that please tell us, please tell us. And the state wouldn't tell them. But be that as it, I'm not. So we'll give a compilation of judgments for my knowledge, just for the assistance on discrimination. Watson will forgive me, my colleagues will be here. I'm deeply grateful to my lords for a very patient, very kind hearing, for having fixed the matter at such early notice. Deeply grateful. Obliged.
May I proceed? My humble prayer before the Lord for direction to the no, for disbursement of my deeds which has been withheld by the opposite party number 5.
And we are going to deliver a judgment.
Yes, sir. Obliged. Please.
Whether your case will come or case will go out, we know.
Within the.
Petitioners filed an objection to the proposed standstill. That is in annexure 1. That is since 27 May 2025 is pending before the opposite party number 2. That here the petitioner we are submitting.
The opposite parties are environmental clearance. Or you have already given.
Yes, sir.
You
That the whole case is that they allege that there is violation of rule 23, 27 and 27 high cooler. Let's see, kindly have a glance to paragraph 8, paragraph 7, 8 and 9 of writ petition. That is the whole case. Paragraph 7, 8 and 9. These people are the villagers. They have filed this case alleging that paragraph 7, 8 and 9. That yes.
Yes.
Your category is under minor number.
How can you know?
You are villager.
You are a villager, you are raising a cause for the public. What is the right?
But in the meantime, auction process is over. At Soirat, now it is operational. Environmental.
After environmental.
Yes.
And everything.
Yes, sir.
Can you put it on
Short
affidavit?
Yes.
Will dispose of. Next Monday, can you file it within 3 days?
Yes.
And you have the council for the party. That after the only. However, India is required to the action. In order for the next.
Petitioner before your authority uses leaseholder of stone quarry. Leaseholder of stone quarry. Leaseholder of stone quarry. Stone quarry.
praying for a direction to be issued to the opposite party or to take preventive measures to prevent theft from his query and to give him police. Milord, the lease was executed. Milord, the lease was executed in the year 2020. I have operated the financial year 2023-24. Then, due to non-raising of the demand, 2024 and 25, I have not operated. Then also 2025 to 26, there is the demand. The 2 years I was absent from I ceased the operation. Then thereafter, when I enter into the query, the local people are not giving me allowing me to enter into my premises, for which I have made several representations and the
Inaction of police.
Action, the allegation is for. Is it? Yes, madam.
The police has not provided the.
I have entered into the premises. They have assaulted me. I registered an FIR. Then
There
they
are
have
two FIRs are registered.
Now, Milord, they have raised the demand, asking me to deposit. No, Milord, no.
The demand is not under challenge.
Then how it comes under this? Not
I am ready.
either treated as a PIL or can be treated as they take the matter.
CRL. Nomenclature is CRL.
What is this?
Criminal miscellaneous.
Wait.
Yeah, Milord.
226.
I just want.
220, Article 227. 227.
Mission is also maintainable. There is no.
Has to go to the comes under the residuary clause.
After amendment in the High Court rule, the nomenclature has become CRLMT. And it is
Petition is registered as CRM.
CRLMT.
No. 220.
That is 26, I'm asking. I'm not concerned with the nomenclature. But under the mandate of the CIS mandate, nomenclature must be one. Sir, how can you maintain it? If we are going to dismiss it. Because then you have to show that you have applied this Priyanka Srivastava, which has been the mandates. And this will show that we will not.
The lordship might fix up another date in the meantime. Another date here also.
What date? You do this, it will be a clear. Restriction, nothing more than. We discuss.
Let's withdraw. With liberty.
What is the proper forum?
No, that liberty.
It's called.
May please the present petition at state level association under the MSB decided lordship and directly from the annexure 2. The resolution, the relevant portion is page 43 minor. Clause 18. For any dispute, resolution of dispute. I am the state level committee association and we are the committee members constituted under the MSME department. That is, I am referring page 43. I am challenging the tender process whereby the state government has decided to hand over the 6 testing laboratories run by the state government. No, where the assumption and where the committee members may. Kindly come to page 18, madam. Page 43, clause 18, madam. As per the Annex 2, that is MSCB Department Regulation. Minor. I am placing man. There shall be grievance committee. So we are the members.
Whatever.
The along with the dependencies of the upper state level, micro, small, and inter association in order to look into the problems of the registered MSCB.
Yeah.
So, according to this, before taking any decision, they must have comfort. They should have consult you. Several times we have submitted dependency, that is on 9-10. Well, Lordship, can you have a glance to? Since 2024, under Annex 9, tender man. They have that's
in the grievance. If there is no grievance, then what?
There's grievance that your Lordship kindly have a glance to what? Your Lordship kindly have a glance to the Annex 8. What is the requirement of the testing? Page starting at page 63, relevant portion is page 65. What is the relevant preface? What is the relevancy of the testing laboratory that has been decided? Because in the year 1963, that document is also available. Minor. Minor.
Of the one raised by MSC students and MSC.
Minor.
If there is no reward raised by MSC, how you are coming forward? If you say that all these actions are must you can be what is your political line in the association?
Because we are challenging the handover, because we are the committee members.
Committee for consideration of the grievance.
If
there is no grievance, then in that event, how can you say that you should be consulted? You should be consulted, you are a part of the grievance committee.
Minor.
Provided the grievance is raised by the medium small scale enterprises.
Minor.
If they have not raised any grievance.
They have already raised the grievance. That is under Annex 9, minor.
They have decided divorce you. Tell us. They have decided divorce you.
On Annex 9, my representation. But that is my grievance, minor. Because one as to the that is my.
Have they taken any decision on the grievance?
No, man.
Then how can
they have not called for the meeting, my lord.
Why they will call?
Because
no grievance. If there is no grievance, then why they will call?
No, because we have come.
Without consulting you or without including you.
No.
They have not considered the grievance settlement. Our grievance is that the testing laboratory should not be given to the private organizations. That is a sole grievance, my lord. Because it is against the rule. They cannot. They cannot hand up.
They have taken that decision
Without consider our grievance. Because
you cannot raise the grievance. You are one of the members of the grievance committee. How can there be a grievance of you? Unless there is a grievance raised committee without you, then
I am not clear, my lord. As per the MSCB rule, every month the committee has to be constituted to consider the grievance, if any. So once they have taken the decision to privatize the testing laboratory, they should constitute a committee. Because
why should? If no grievance is raised by these MSCs, then why they should constitute a grievance committee? I'm just asking. Grievance committee means the committee to consider the grievance raised by this MSC. Tell me, we are breaking our head to understand, has this grievance committee decided any grievance without you? I can understand that you are one of the organ or the constituent of the grievance committee. They cannot go without you. Have they? You are not saying anything. You are saying no, they have not decided anything. Then if they have not decided, then what is your problem? We are asking you.
They have violated all the rules.
Who are you to say? Let the participants come and say. Who are you?
Because ultimately the members of MSME will be they will be affected, my lord.
They are not coming forward, sir. If somebody says I am not affected, I am happy. Will you inject them that you are unhappy?
The association, out of the five petitioners, three petitioners are members of committee. Other two are also not members of the committee.
Why don't they come forward?
They are also the petitioner before lordship.
What?
The petition number 3 and 5 are they are not the committee members, my lord. They are the association, my lord. May I pray for tomorrow so that I can satisfy on this point, my lord?
You cannot, because you are jumbled up with the facts. You are jumbled up with everything. You making a lot of confusions. The clarity is not coming. Sir, you are not the PIL.
No, I am not on the
That's why I
PIL.
am saying. See a person actually who are not.
May I pray for tomorrow so that I can clarify, because they have violated all the rules. Because I can.
Sir, who are you? Locus.
On that
You are locus.
on that
Tell
point.
me locus. It's not a public interest certificate.
No, this is not.
Then who was the locus?
On that point, may I pray for only tomorrow, my lord. On that point.
Since we interact, henceforth I will keep mum.
Sorry, next time. But
Will dictate immediately. The moment I interact, it gives you a punishment to get the adjournment.
no, I'm not seeking. I am not seeking any adjournment because on
What is this? This is called adjournment.
I am extremely sorry, but and
You are
actually
not seeking adjournment, but seeking a time to come and clarify. This is called an
I'm extremely sorry. I'm not prepared on that point because I'm factually I have a very good.
You are not prepared also, it's called adjournment.
I'm sorry, extremely sorry, man. Only for tomorrow on that point, man. Otherwise, I have on rules, on violation of rules.
Nothing more. For you, you are not a person. You did not participate in.
Because they on the PPP mode, they under the PPP mode also.
Right.
On they are transferring on the PPP mode.
Whatever.
But that is against the rule.
No.
I can
Who are you? I'm again saying locus.
local only for tomorrow. Please, because all the MSME will suffer, my lord, by this process.
Don't discount the cause of others.
No, I am also a MSME. I am also I am running a small scale.
And did you participate?
There is no scope of because this is a testing laboratory.
Did you participate?
My lord, there is no scope of participating. Kindly understood, my lord. This is there is no scope of participating.
First matter for dictation. So we are departing. First matter for because we want to adjourn to tomorrow. I can get it only 2 minutes.
My lord, I'll try my best.
Only 2 minutes.
Fine.
With the speaking of the clock.
If I may please your lordship, by this repetition, I'm challenging the auction process, man. Wherein
After participation.
I am a participant. I'm the second highest bidder. There were three.
The process is challenged.
Yes, my lord. The whole process is challenged because the opposite party number 4, who is the first highest bidder, there are three preconditions for being a successful bidder in the said auction, ma'am. That is, I have narrowed it down at para 5 of my writ petition. That is, the bidder should have a valid GST registration number usable for the purpose of leasing of the Biju Kalyan Mandap Odogaon. It is called by the Odogaon NSE, ma'am. The bidder should submit at least 3 years of experience in work of similar nature in the last 5 years. Then the bidder should be a resident of Odogaon NSE, madam. So my humble contention is that if the highest bidder does not satisfy the first two preconditions, madam. Because after the RTI reply, I went through his application, my lord. He has given a GST registration certificate of an electrical store, my lord. So he is not involved in the matter of managing any mandap in a similar institution, be it a mandap, be it a lodge. Yes, my lord. The tender document. So, yes, my lord. My lord, may see the tender notice that is at Annexure 1, page 16, my lord. Sealed quotations are invited from the intending persons / agencies having valid GST registration number for taking lease of Biju Kalyan Mandap of Odogaon NSE on monthly rental basis. So here I am interpreting that the GST registration number which is being called for should be of the nature. Yes, my lord. Two of the similar matter.
Valid GST. But he may be involved in similar matter of work earlier.
No, that is the reason, madam. That is my second point. He has not given any experience certificate to that effect as well. That is my second point of submissions, madam. His whole application is at Annexure 2, my lord. Therein, that is at page 20. Therein, he has not provided any either experience certificate or any letter or any document showcasing that in the last 5 years, for 3 years, he was involved in a work of similar nature.
What is this?
You know, tender is quoted by notified area council Odogaon. Notice has to be seized.
My lord, I have filed an otherwise, my lord, it would be. Then, my lord, I may pray. I'm not available from 19th to 4th January. Either it may be called before 19th or after 4th January. If it is possible. Much obliged.
Item 14, simply euros. It is related to payment of escalation, my lord. It is approved and calculated, lord. That is page 107, your lord. Calculated also. Pursuant to approval of Annexure 1, page 107, your lord. Annexure 5. After approval, lordship of is is it?
December. Item
May please, lordship. Because all the 6 items, lordship, pertain to tender, lordship, like NAC. No, lordship. I used to appear. Lordship, here, lordship, the tender, the date, 2 dates are very important, lordship. Lordship, straight I come to Annexure 1. The date of tender, lordship, 25/25. And in personal tender, all the 6 bidders, lordship, become qualified. And as per rule 353, lordship, their lordship ought to have been issued with work orders because
The order issued?
with work orders, lordship, and followed by agreement. To all 6 lordship. And lordship, 353 lordship for NDC lordship. Lordship. And they did not, lordship, because the executive officer did not issue any work order. We approve this honorable court, lordship. And this honorable director, lordship, please execute it. No, lordship. In consonance section 3, rule 353(5 is a direct order, lordship. Lordship, 353(5) rules says, lordship,
within 2 months, you have to bound to execute entire work order, Lordship. Lordship, this court directed to execute the work order, Lordship, in the direction for Lordship. But the executive officer, instead of issuing work order, Lordship, now he has rejected our bid, Lordship. And very peculiarly, his bid, Lordship, kindly state I come to Lordship. Annex 7. Entire cancelled, Lordship. Lordship, he's not, even if he's not authorized, it is the only tender coming to the municipality. And municipality says issue work order. And NAC says issue work order, Lordship. But this executive officer, relying upon subsequent letter of the state government, that will also kindly come to Annex 7, page 45. Very peculiar order, Lordship, is very critical order. And what he says, Lordship, kindly see. Page 45, Annex 7, Lordship. Lordship, got it, Lordship.
No, it is copy included. Where is the copy? Of the Housing and Urban Development Department, where is the letter? It is the media letter number 7, sir.
Annex 8, Lordship. I have 8, page 46. But it is first thing, Lordship, subsequent tender. It is no way related to the present tender. That's the Lordship. This is the tender of May, Lordship, and is relying letter of.
It's the notified area council of Kasinagar. Notice has to be issued. Yes.
Lordship, this should not come with further tender, Lordship. Lordship, one matter I have support, Lordship. Lordship, you should notice they have come up with a new tender, and Lordship.
Then you come with the application. Think that file.
Lordship. Lordship, first year they will appear, Lordship.
Here.
1, 2, 3, you are appealing.
1, 2, 3.
1, 2, 3 state, and 6 have take notice, Lordship. 6 have take notice. 4, 5, 6, Lordship.
Petitioner is the big class contractor and work as an awarded to. That is 18 the work order miller. As for the work order, the work should be completed within 6 months. So, due to public hindrance miller, the work could not be completed in due time miller. That the petitioner filed several representations miller. Let me see the page 105, the representation. The district administration solved the issue in the month of February 2025. The page 105 in their so-called the categorically mentioned miller. The dear sir, last paragraph miller, page 105. Dear sir, in inviting reference to above, it is record here that after solving the last year problem for Ma Dhunamunda Ancholika Krusaka Mahasanghar Ranapur, since last 2 months, the practical no work has been executed. In fact, after the issue was resolved, the work could not be started because of there's a hard stone in granite water.
What is very serious against.
Yes, that is Lordship.
112.
Yes. Because of the first initial stage, public hindrance, the work could not be completed. Thereafter, the issue was resolved. In the month
How
of
resolved? How resolved? Where is it resolved? Tell me.
Lordship, the month of February 2025.
Yes, where for you to doctor.
They are so good, Lordship.
They are shook.
105.
Not resolved. What do you mean by the word resolved?
So,
They have given you a notice.
Yes.
To state satisfactory why the work shall not be rescinded. The last.
That's so good. They mentioned that last year they are solving the issue. Top line, one line they were mentioned, the last year they solving the issue. Thereafter, what?
Yeah, I do not find. Tell me.
105 Lordship.
105.
Last paragraph. Here, sir, in inviting to reference to above, it is to record here that after solving of the last year problem of Ma Dhunamunda Ancholika Krusaka Mahasangha Ranapur, since last 2 months, the practically no work has been executed.
This is what they have given us.
Yes.
So where is the result? They say not in each who have.
Yes. After February, my lord, no work has been executed because of.
Then what can be done then?
my humbly prayer that
Then they issued a super, then what happened?
then find my reply, my lord.
Then
Page 106.
ultimately what decision?
Ultimately, they withdrawn the work because of it's a violation of clause
Are you challenging that order?
My lord,
Are you challenging that decision of rescinding the contract?
this order is challenging the present.
This one.
Yes. 108, my lord. Page 108.
Yes. What is the wrong in it?
My grievance, my lord, that is not my fault, my lord. That is initial public hindrance was put to complete.
Is there any problem with the these rules or clauses go higher up?
There is no clutches in there. There is no clutches so far as the 70% work has been completed. Because of this, my
So
lord.
the other side,
File your affidavit.
Yes, madam, we will file affidavit, madam. But one document which is not annexed to the writ petition, we will file with affidavit. They were informed.
in a week,
With a week. Yes.
work schedule? No. One. Rejoinder 3 days?
Yes.
After 40.
Rejoinder within a week.
December. 7 days.
Degree engineer and A-class license, contractor license. He submitted the tender process and his bid has been rejected. He will also kindly come to page number 140 minutes. Page number 140, annexure 8. I am entitled to participate in 3 tender processes without depositing the AM. 140, annexure 8.
It's a word.
Double 3279, WBC number 33279.
7-9.
Annexure 8 minutes. Annexure 8. No, 140. 140.
Sir, it is 179.
This is different. Double
17.
double 3.
November 2025.
There are two different items.
79, sir. And sir, it is 179. You check up in the instrument.
There are two different data applications. Your Lordship, I pray, Your Lordship. Your Lordship is probably taken up WPC 33279 or next item, Your Lordship, kindly. I am extremely sorry. Next sub item, Your Lordship, kindly. Both the same. Next. Mile. I am extremely sorry. Tender process without depositing the EMD for 3 tender works. I have without depositing EMD in 2 tender works I participated, but they rejected on the ground that I have participated in 3 tender works without depositing the EMD. That is wrong. You can also kindly see annexure 8. You can also permit by place as per OPWD code. And subsequent clarification, Chief Engineer Buildings Odisha Bhubaneswar by letter number 1 to exemption of EMD to the engineer contractor will be allowed for maximum 3 week works in a financial year. You have availed 3 exemptions for the financial 2025-26. two of which has been verified from CDMS portal and on document received from the Chief Construction of Rural Works Circle Baripada by letter number 6/11/2020, it is found that you have availed another exemption of EMD for the work under Rural Works Division Baripada during participation of the tender detail which is listed below. Now, there whether EMD exemption column number 5 may kindly be seen. Whether EMD exemption availed during the participation of the tender, yes. Actually, that is wrong. If you also kindly come to the next page 141. I have deposited EMD. Annexure 9. The letter issued by the Superintendent Engineer RW Division Baripada.
Then why is that shown? Shown it, yes.
No, they are, this is their letter notes.
How can it be?
Well, I have instance.
If he has deposited, then how?
Well, I have received instruction in this matter.
The engineer has said.
Not only these 3 works, Millard. Actually, Millard, my instruction is the petitioner has availed 5 number of works. I can file an application.
How can he give an exemption? 5 years. So 2 he has deposited and 3 exemption.
Yes.
I am entitled to 3 exemptions.
Oh, that is what is saying.
Millard, the second paragraph.
Obviously.
How do you deal with the 180 election line? How can you do? I think the embargo is after 3.
Is it restricted to only Baripada or anywhere during that financial year? Two things. The financial year is 2025-26. So is it restricted 3 works within the same district or it pertains to other districts also? Making all the 5 may not be in the same district.
But I would take further instruction. Need to file an application.
For the instruction next Monday.
8 December. Item 18.
This was a small scale manufacturing unit engaged in designing, printing, and turning up and paper works. In this case, a tender notice was quoted by NS 3 page 16 LRC. Where in LRC relevant page 20, page 20, the eligibility criteria. So item 4, my lord, the agency must have the printing unit in Bhubaneswar category. A self-declaration or builder's letter that clearly mentioning the address must be there. Here the petitioner's unit is at Bolangi. They have confined it without any rationality, my lord, to only between the 2 cities. Bhubaneswar and Cuttack must be unique. But thereby I debarred from participating in the bid. I am MSME, my lord.
It can definitely, or some further reason.
So, nothing, my lord, no rationality at all.
One judgment of the Supreme Court is there. Judgment is against
My lord,
Supreme Court has said no violation of Article 14. I correctly remember.
so the judgment has said the Reliance Energy Limited case. The lordship has said that the doctrine of level playing field must be there. Tendering
I
authority.
understand, but there is that's why I'm asking you.
Yes, ma'am.
That for that special category of cases where the distance is the very important factor, it can restrict it. Everything I do not know, printing of very materials that should be within the vicinity.
My lord,
Well, nothing, sir. No region has been assigned. There must be your lordship, must be rationality for your lordship. The classification. Why the cut of sir? Why my minute?
Teacher.
Yes, ma'am. Naturally, man, printing. Your lordship, see. Your lordship, page 16. Your lordship, see, NS3. Designing and printing of training materials for farmers under national mission on natural farming. I mean, similar case also. The printing also have been awarded. In earlier case, in NS4, your lordship, I given page 25. Earlier case also.
Who is the parent?
18. CNR is
Okay, sir.
December.
Page 20. Page, if you also look at page 23, annexure 1, 10, 11, 25, order of rejection of the bid on technical ground. There are two parts are there. First part is that you found to be technically disqualified under 4.1.13. And the second part, they returned the bank guarantee and other things. 4.1.13. So it is actually starts at page 42, but this 4.1.3 is at page 63. Experience criteria, but if you also kindly turn to the qualification request, it is page 4.1.1 at page 61 first. 4.1.1, page 61. This is the work of a mines operator, mine operator. Technical criteria is 4.1.1. The bidders shall have successfully executed similar works for the considered mineral for a minimum amount of either 11.68 crores in case of single work or either 19.46 crore in case two works in any one of the immediately preceding 10 financial years, excluding the year of floating of the RFP, or that is a valuation part is for a minimum production not less than 3 lakhs metric ton from any of the single open cast mine or a minimum production not less than 5 lakhs. Both the things actually are applicable. I have given the certificate also experience. But you also can do the similar work is there, defines in this clause. It says similar work means drilling, excavation, transportation, hauling of ore, waste. Below beam. Below beam. For the experience certificate I have given, if you looks at similar work is there. No, not similar work. And the considered mineral also. That is important. Considered minerals shall mean ore, chrome, manganese, bauxite, coal. Considered both coal. We are doing execution of coal. Yeah, coal is right. So if your lordship looks at page 142. This is the experience certificate method. Eastern Coalfield. The experience certificate will show is for the period 1/4/2023 to 31/3/2024. In the first paragraph, last line, work executed from 1/4/2023 to 31/3/2024 with the value of work done by them as given below. Is it 33 crores, 331 crores?
Yeah, 33.
33 crores, 10,70,000, so and so on. But this has been done by a JV, if you kindly mark.
Nine the lead part.
The JVs are three partners. Budhira Mines and Construction Limited is the lead partner, and two other partners are there, 50%, 30%, and 10%.
Next page.
The next page, if one looks at 33/2025. This is for the period 1/4/2024 to 31/3/2025. Value of the work is, if one looks at 56 crores, 18 lakhs, 1,902 and 25 paisa only. And the JV partner, lead partner, 60% share. But 60% counts to 32 crores.
No, 42.
For 2 years, that's right, 2 years.
Much above 20.
It's much above the requirement that is given. But one thing they may say, actually, you are that's for JV and you are individually applied, but that is also not a criteria. If you look at the central circular document.
See tender. Policy.
These are e-tender notice. Percentage share of each experience.
Constituting of the joint venture company and the percentage of shares will be evaluated.
So there cannot be a ground to reject it on the ground of eligibility criteria. Technicals have fulfilled all that, much more than that actually.
My lord, my up-to-date instruction is that third party right has been created, tender process has been completed, and the letter of intent has been issued in favor of the successful bidder. He accepted that, thereafter letter of award has been issued. Now, my lord, may time turn to page 61, clause 4.1.1. No, my submission is not that, my lord. 4.1.1. Clause A, my lord, we can see the opening words is the bidder shall have. It is confined to the bidder shall have. Then, my lord, we can see next page.
What is this document?
So this is not issued by the tender issuing authority.
No, this is not issued by the. Sir, this is actually East Coast Coalfield, Coal India Limited.
All India's policy.
Is their own policy.
No, this is the policy or
This is the tender notice, and according to that award that we are executing in Eastern Coal.
No, some tenderer they may do something, but some is not.
No, this is actually policy decision of the central government.
Where is the policy? I do not find that policy decision.
Coal India.
This is the first document is a e-tender notice.
Yes.
Issued by the.
Yes, course, sir.
I think that clause.
That 5.
They incorporated those clauses. These are not the policies. This
is policy decision.
No,
This is the tender on the.
they,
But
you know, The author of the document, the tender committee, it is a freedom is given to them to incorporate some clauses, not to incorporate some clauses. It is up to them. You cannot borrow that the other, say I would say the rival companies or subsidiary company or the lead company that have floated and which are incorporating this.
Sir, I just wanted to bring it your notice about the tender that was floated. No, and you leave aside that, my lord. No, forgetting that, my lord, let's be kind to see. The JV they have not indicated your experience in JV will be excluded.
No, something is not included. Question of its exclusion does not arise.
But here bidder means bidder includes any bidder even in JV.
No.
But if you are saying
If it comes, no difficult.
Here clauses are different. My lord, can you page 62 clause 4.1.6.
No, I got it.
Well, here the requirement as per the tender call notice is that the bidder who is bidding, submitting the document, the experience certificate should be in its favor. My lord, can you see who is the bidder here? Page 137, my lord. Yes.
Rather limited term.
Yes. Now the experience certificate is of a JV.
experience is of a JV. Experience maybe for JV, but experience of the work, my lord, what they want. The bidder shall have the experience. Bidder has the experience.
Successfully executing that work.
Who has executed the work? The bidder has executed the work. He was the lead partner. He has executed the work.
He is executing till now.
The requirement, my lord, you can see page 62. Just clarify this position.
In the JV, when he was the lead partner, he executed the work. They want an experience. But they cannot exclude by experience so far as the JV part is concerned. Here the bidder is one of the leading partners, lead partner of the JV. It is still continuing to execute works. Same nature of work, identical work. So my experience of the work cannot be taken out from the purview of consideration. And bidder doesn't exclude that from the lead partner or the partner of the JV. They are also partners and they are also individuals.
Here, my lord, may kind turn to page 62, clause 4.1.6, my lord, may kindly see. Here it provides that the bidder can be either a registered partnership firm or a company.
I've seen that, or LLP, whatever.
Yes. And clause 4.1.13 is very clear, my lord, can see the eligibility.
Or it will be on experience and
The last one, my lord, can see the eligibility criteria of the company LLP is liable to be evaluated on the basis of the experience and eligibility criteria of the company LLP. Last word is itself.
Yes, 60%.
Yes. 50%.
So this certificate is not in favor of the bidder. Bidder is A. Then certificate of experience is in favor of A, B, and C.
Expertise and experience is material matter. If somebody has executed and continuing to execute huge amount of work, in fact, much more than their requirement, you cannot throw them out from purview of consideration.
No, that is exactly the same. The experience cannot be excluded for the personal purpose of consideration. That and the percentage of work is 60%. He has got the increase.
People submitted by the petitioner is given. Yes.
My challenge here is to the discharge.
Yes.
But may I request you, Lordship?
Yes.
Well, cancellation of tender. Well, after 3 months. Well, after accepting earnest money of 35 lakhs without assigning any reason. The presumption is it's for an external motive, exterior purpose. Well, I'll rely on the judgment, but before your Lordship comes to the judgment, this is also contrary to the procurement policy and the rules governing these tenders. Well, please straight away, may I show your Lordship the discharge notice. Well, please come to page 182.
Yes.
Well, this is dated 19th November 2025. Your Lordships may just in this context make the note that the tender was floated on the 15th of April 2025 and was thereafter uploaded in the e-portal on 26th June 2025. So,
Voice are coming in my ears, that's why. Is somebody is talking on video or something like that?
Your Lordships, kindly have a look at page 182. Well, at 182, may I just read this? The tender for the work, chartering of green truck transition program compliant, manning operation maintenance and complete technical management of service provider owned one number of 660-ton bollard pulled new battery electric truck for 15 years at Paradip Port Authority against e-tender call notice such and such, dated 15th April 2025, is hereby discharged for all purposes without any financial liability to the Paradip Port Authority. Then your Lordship will kindly see the next page, 183. Well, this is the tender summary report. Well, please have a look at my tender summary report. Well, these were the 3 bids, 4 bids that were received. One is from Industrial Handling Private Limited. Please see the status admitted. So, they're techno-commercially qualified because admitted, pre-qualified / technical. 2, Netted that is the petitioner, qualified. 4, 3 is not admitted, 4 is admitted. So, there are 3 technically qualified bidders. So far as this is concerned, now if your Lordship will kindly see, the last table, corrigendum details, discharge, yes, due to administrative reasons or issues. So, there is no reason at all that is cited. Now, the tender was floated pursuant to a public policy decision of the government. But if your Lordship will please have a look at here, page 148. This is a communication by the government to Indian Ports Association, that is all the ports, of a standard operating procedure for green tug transition program. This followed, the global discussion on green energy, and it was decided that ultimately all the ports must operate green tugs. Now, if your Lordship sees page 149, this is the green tug transition program of the government.
140?
Green 149.
Yes.
Now, please see 150. This is the background in which this program was initiated. In consonance with the Paris Agreement, wherein nations pledge to reduce carbon emission and contains the temperature rise within 1.5 degrees centigrade by the end of the century at such and such. Now, India announced its enhanced climate commitments, the Panchamrit, including its long-term strategy to achieve net zero target by 2070. The action strategy includes reduction in carbon dependency through innovative policies such as National Green Hydrogen Mission and development of integrated, efficient, inclusive, low-carbon transport system amongst other action plans. Now, dear Lordship, there's discussion. Please come to 4 at page 151. Harbour tugs form an indispensable part of port operations carrying out operations like berthing, unberthing, ship assist operations, pushing, pulling, etc. At present, around 400 tugs operate in ports of India across public and private sectors. Harbor tugs undertake high-powered operations only for a very short duration of time, which is typically less than 5% of its total operating hours. Values may, however, vary. By virtue of its unique operating profile and closeness to the port throughout its operation, harbor tug provides a very suitable platform to adopt green solutions such as electric propulsion systems and alternate fuels, thereby reducing emissions at ports without compromising on the operational aspects of the vessels. And then 6, in view of the above, on 22nd May 2023, on the sidelines of the Chintan Shivir organized by the Ministry of Ports, Shipping and Waterways, Honorable Minister of Ports, Shipping and Waterways announced the launch of India's Green Tug Transition Program as part of the Panchkarma Sankalp. Subsequently, the approved standards, tug designs and specifications Green Tug Transition Program was promulgated by the Ministry of Shipping for promoting the domestic tug industry and progressive replacement of existing diesel-powered tugs with zero-emission tugs. The designs and specifications under such and such shall be published. Then, my lord, this provides for a phased implementation. That's Part B at the bottom of page 151. Well, if your lordship will please have a look at, well, now, well, at bottom of page 151, well, this is the phase-wise, well, introduction of, well, the program. Well, here, lordship will find by the end of this phase, this is, well, the first phase. Well, at page 152, I'm sorry, 1st October 2024 to 31st December 2027. Procurement, chartering of at least 2 green tugs, each by 4 major ports. Well, this includes.
Last one is PPA.
Yes, well, PPA Paradip. Now, well, here, then, well, phase 2, phase 3, phase 4, and ultimately the object is to attain 100% well, green tugs in all the port operations. Now, well, thereafter, you'll also please have a look at, well, the general terms and conditions, well, for which the tender was floated. Well, this is, well, the policy decision. Please come to 159. Well, to attract bids, it is decided at least 12 weeks bidding time will be provided. That's clause H at page 159. I'll not trouble your lordship with the other terms. These are not relevant. Now, the tender is thereafter floated. On 15th April 2025, it is uploaded on 26th June 2025. Please have a look at the tender. That's at page 28. 28. This is the Paradip Port Authority. Tender for chartering of green tug, marine operation, maintenance and complete technical management of service provider owned 1 number 60-ton bollard pull new battery electric tug for 15 years. Well, we have avoided, my lord, the unnecessary terms here. Well, please have a look at, my lord, these timelines at page 32. Bidding documents to be downloaded by 26th June. Last date of, my lord, submission of bids is 21st July. Opening of bids is 22nd July. And then, my lord, one more important clause is, my lord, page 33. My lord, this is the estimated cost. Page 33. Let please see the name of the work. It is the same chartering. Cost of tender, then estimated cost of hire. Estimated cost put to tender for hire charges for 1 year is 24 crores 47 lakhs 28,667. So, my lord, they know, my lord, what is the, my lord, requirement and what is the price estimation. Well, there is mention of a pre-qualification criteria which your lordships will find at page 49, clause D. Now,
the question is that you may be eligible participants. They have cancelled.
Now, let me. No, now, my lord, here, so far as this is concerned, please now see, my lord, what can be the basis of cancellation. My lord, please have a look at, my lord, page 184. This is the manual for procurement of works. And, my lord, this is framed, my lord, in line with the general financial rules of 2017 as amended in 2024. And these your lordships have held to be binding. Cannot be departed from.
185.
Well, lord, please have a look at 184. Well, lord, this is, well, lord, the manual, well, lord, that your lordship finds starts at page 185. 199. 5.6.8. Rejection of all bids or retender. When can this be done? The procuring entity may cancel the process of procurement or rejecting all bids at any time before intimating acceptance of successful bid under circumstances mentioned below. In case where responsive bids are available, the aim should be to finalize the tender by taking mitigating measures even in the conditions described below. If it is decided to rebid the tender, the justification should balance the perceived risks in finalization of tender, marginally high rates, against the certainty of resultant delays, cost escalations, loss of transparency in re-invited tender. After such decision, all participating bidders would be informed and bids, if not opened, would not be opened, and in case of manual tenders, be returned unopened. The situations where the bids can be rejected are listed. A. If the quantity and quality of requirements have changed substantially, or there is an unrectifiable infirmity in the bidding process. B. When none of them.
Responsible.
Now, my lord,
Means the technical qualification.
well, that is also not a problem. So, my lord, none of these conditions are satisfied.
Yes.
Now, my lord, I must point out to your lordship, my lord, that there is, my lord, like in all tenders, an omnibus clause, my lord, which, my lord, ultimately says that, my lord, they may annul all tenders without any. Yes, but my lord, that must be read and understood. My lord, that is at page 53. Now, my lord, in view of, my lord, the circular, that is the manual for procurement, my lord, this, my lord, clause, after, my lord, clause O, must be read to be, my lord, understood along with these, my lord, guidelines. It cannot be, my lord, anything else. Now, my lord, may I just show your lordships, my lord, one more document, my lord, which is not a part of, my lord, the tender papers. My lord, this is the general financial rules. My lord, this is the financial rules, my lord, on the lines of which, my lord, this manual for procurement of works is modeled. Well, I should just hand it up to your lordship. Just show your lordship, my lord, rule 173.
Page 43 and 48 of that punch.
May I request your lordships to just have a look at one page? It's a very substantial document. Page 43.
I may be given a copy of.
Yes, yes. I'll give my lensman a copy.
Print out this. I will prove.
Yes. Well, at page 1.
Repetition.
Well, this is not a part of the repetition. Repetition has.
You are separating this general financial rules.
Yes.
Page 43.
Yes.
Relevant part is page 48, small 19.
Well, at page 43, your lordship will find rule cell 173. It talks about transparency, competition, fairness, and elimination of arbitration in the procurement process. Now, my lord, this, my lord, continues for the next few pages. Please come to, my lord, now. My lord, page 46. Roman 9. Well, lord, this provides for rejection of bids. When can all bids be rejected? That is, my lord, tenders be cancelled. Okay, put your lordship.
46.
Well, at page 46, well, at Roman 19, rejection of all bids is justified. Well, that is cancellation of tender when all bids are rejected. Rejection of all bids is justified when A, effective competition is lacking, B, all bids proposal are not substantially responsive, C, bids proposal prices substantially higher than the updated cost and estimate, and well, none of the technical proposals meet the minimum. Yes, absolutely. And well, this is GFR 2017 is the procurement policy. Well, a part of that with data elaboration is the manual for procurement of works, which I have shown you, lordship, which forms a part of the tender. Now, so far as this GFR is concerned, well, your lordships have held that this is now binding. This is not something that can be derogated from the suite political party. Well, may I in this regard show your lordship, a judgment of the Bombay High Court. Well, this is reported in 2023 Supreme Court cases online Bombay 1267. Well, at 23 Supreme Court cases online Bombay 1267. It's a division bench of the Bombay High Court. 1267. Well, there's a lot of my lord referencing to my lord the GFR. But my lord, if your lordship will straight away please come to paragraph 53. Well, there's discussion with regard to various terms of the general financial rules, but my lord, for the present purpose, I think, my lord, I can only, my lord, draw your lordship's attention to paragraph 53. There is no dispute that the RFP does not define the word bidder in any of the clauses of the document. There is also no dispute on the fact that the respondent number one being a port authority established under the Major Port Trust Act and under the control of the Ministry of Shipping, Government of India, the provisions of General Financial Rules 2017 GFR are made fully applicable to the authority's functioning, more so in the areas of procurement of goods and services. Now, my lord, this decision was, my lord, also followed by the Calcutta High Court. My lord, and my lord, the Calcutta High Court, my lord, proceeded to pass an interim order in one of the matters upon accepting the binding nature of these, my lord, rules. Well, this is reported in 2024, SCC Online Calcutta 4561. Well, at paragraph 2. And well, it is upon placing reliance on the Bombay High Court acceptance of the fact that GFR is binding, that ultimately the court proceeds to also pass an interim order.
Yes.
My lord, my very respectful submission for your lordships is that, my lord, in view of the manual for procurement works, the GFR, my lord, rejection of tender must, my lord, ultimately conform to, my lord, one of these norms. Well, this manual your lordship will find is, my lord, ultimately. No, well, the GFR, well, that's right. Now, well, it is. Well, so far as the manual is concerned, the manual is, my lord, modeled on the GFR. It is, my lord. Of course. Well, I don't say that. Well, it is not legally enforceable, but, my lord, the question is, my lord, once there is a manual and it is, my lord, made, my lord, enforceable as a standard operating procedure, my lord, that is the language employed. Well, then once you have to depart from the standing operating, at least, my lord, my lord, have to have an explanation. No, my lord, third party.
And wanted to enforce it, then in that case, because
well,
those line of judgment where say that the executive instructed is not statutory
no
document, not legally enforceable.
Well, executive instructions, my lord, of course. My lord, are, my lord,
like a land manual in West Bengal.
Well, your lordships have also held.
Does not have the legal faculty.
No, that's right. That's right. Well, I'm not saying that.
There's nothing, because there is no close which can be traced for this manual.
Well, I have twofold submissions. Well, first of all, my lord,
as this is concerned, this general finance rules, at least the Bombay High Court has said that it is applicable to a bond because of the forecast.
Yes. And well, so far as this is concerned, this is also, my lord, issued by the Ministry of Shipping as a standard operating procedure. And well, what is important is, all the other port trusts, my lord, all the other four major port trusts have already, my lord, put this in motion, and some of them have already completed the acquisition of trucks. My lord, the Paradip Port Trust also, my lord, initiates the process. From June, my lord, ultimately takes earnest money from the bidders. I am out of pocket, my lord, because I wanted to bid for this. I have stated in my petition I did not participate in other, my lord, tenders because I wanted, my lord, my capital to remain available for this particular project because, my lord, this is capital intensive. And, my lord, ultimately the tender is discharged. I would have appreciated if there was a, my lord, even an iota of a reason given. But it said for administration, particularly in the, my lord, prospectus of the general financial rules and the requirements. Now, my lord, here the law is also well settled. My lord, 2024 in a very recent judgment, my lord, following, my lord, some other judgments previously, my lord, passed by this honorable court. My lord, in Subodh Kumar Singh, the Supreme Court, my lord, in fact set aside a cancellation of a tender, saying that, my lord, it is arbitrary. And it is without reason. My lord, the judgment may not be factually, my lord, very similar. But it is a very, my lord, long and elaborate judgment. I'll give your lordship the citation. I also hand up the copies, but my lord, here, my lord, only to cite that, my lord, ultimately, this establishes two things. One is, my lord, if there is a tender, my lord, in which there are bidders who have participated, and my lord, ultimately their bids are ultimately rejected because it amounts to rejection of all bids, that is cancellation of the tender, then, my lord, they acquire a locus to challenge. Because, my lord, it is on one such challenge that the Supreme Court entertained the challenge and ultimately came to the conclusion that, my lord, there was no basis for rejection of, my lord, the tender or the bids. And, my lord, this also, my lord, took into account, of course, my lord, the causes that were ultimately, my lord, shown, my lord, on affidavit by, my lord, the authorities concerned as to, my lord, what prompted the rejection. And, my lord, the Supreme Court found that this was absolutely bogus. My lord, there was no real basis for, my lord, rejection of bids. But, my lord, I will not, my lord, formally, my lord, read paragraphs of this judgment because, my lord, it is not factually, my lord, similar. My lord, kindly, no, sir. Don't multiply this issue.
It will list of it's the.
My lord, the only thing is, my lord, so far as this is concerned, so therefore, my lord, this gives me a locus to approach your lordship's, my lord, court. And, my lord, ultimately, my lord, in the absence of anything else, my lord, certiorari is what's called for. My lord, your lordship can, my lord, in fact, call for the reasons as to what prompted you to, my lord, ultimately cancel the tender or discharge the tender, because, my lord, just citing administrative reasons, my lord, really cannot be good enough. Because, my lord, you have created a legitimate expectation. You have, my lord, ultimately invited the parties to alter their position to their detriment by, my lord, remaining invested in the tender, my lord, by depositing earnest money. So you, my lord, owe them, my lord, at least, my lord, some spectacle of an explanation. So, my lord, this is my essential ground for challenge. Well, and, my lord, with the greatest respect, in the absence of any explanation in the discharge notice, and, my lord, in the absence of, my lord, anything, my lord, to show that the tender was unresponsive or did not meet the criteria prescribed in GFR or in the, my lord, SOP, standard operating procedure, my lord, there's no real basis. Now, my lord, they have, my lord, ultimately, my lord, convened a meeting on Wednesday. That is, my lord, on the 3rd of December. My lord, for, my lord, floating a fresh tender on the subject. My lord, that is, my lord, what has prompted me to approach your lordship's court with urgency. My lord, this is really, my lord, the short question, nothing else. My lord, if my
What was your position in that tender? Because I do not find this.
my lord, financial bids have not been opened. My lord, I may not succeed financially.
That appears to be a replay.
Yes, the consortium member, Netincon. Netincon has also filed the.
My lord,
Page
that is, my lord,
183.
my lord, I am, my lord, a part of the Netincon consortium.
Page 183, your lordship will see. Petitioner's name is not there.
No.
That is what I just wanted.
My lord, there are two writ petitions. My lord, there is also a writ petition that is filed by, my lord, the consortium, which is Netincon, which has not appeared in your lordship's list. But, my lord, Replay is the, my lord, lead member of this consortium. And, my lord, Netincon is one of, my lord, the bidders. My lord, your lordship will find that the three technically qualified bidders includes the name Netincon. Replay is, my lord, the lead member of this Netincon consortium.
That's
in the appears to be a corporate entity that says.
Yes.
Shareholder or a major shareholder or.
We are a
My lord, Netincon is a pro forma party here.
We are a group company, we filed a joint bid. We are a group company.
Well, I understand, my lord, it's a group company which filed a joint bid. But, my lord, so far as Netincon is concerned, Netincon has also individually filed a writ petition, which unfortunately, my lord, was not mentioned with your lordships. It is filed, it is numbered, but it has not appeared in your lordships.
Same day it was filed, it was mentioned.
In fact, the present petitioner is not the lead member. That also is there in paragraph 14 of this writ petition. Page 7, paragraph 14.
Well, there is, well, I'm sorry to interrupt my friend, Malad. There is, in fact, a decision of the Malad Division Bench decision of Delhi High Court, which has considered Malad this Malad particular manual for procurement. And Malad in a writ petition has entertained Malad writ petition Malad on the basis of this manual for procurement. Malad, may I just hang up?
There is no difference, but because you never participated.
No, we this is
JB, that's also Netincon is the lead member, Replay is the other member, it's a consortium. Paragraph 7 is the party.
Well, please have a look at
He has come up in a different manner. But this
My lord, in this repetition, my lord, one of the, my lord, members of the consortium has come. My lord, India, my lord, kindly give me a word.
The Port Authority has written this letter part of this. With reference when you have participated as a joint venture of Victory. This is the petition. This my petition page 141.
Well, at page 141 of the repetition, well, this includes both the consortium agreement and the letter written by the Paradip Port Authority to replay to Netincon, referring well that replay is my lord.
What is that?
Well, this is a joint venture. Please have a look at page 141.
Yes.
Well, this is my lord, a letter addressed by Paradip Port Authority to my lord Netincon Marketing Private Limited. Well, this is with reference to the sea tender. With reference to the above, it is to inform you that you have participated in the said tender as a joint venture with Replay Shipping Private Limited. Kolkata. And well, in this regard, you are requested to submit audited profit and loss and well, financials for Replay for the last years, which has been done.
The agreement is in 130.
And well, the consortium agreement is that
Also balance sheet for the last year.
that was also
That was given.
and well, the consortium agreement is also part of the repetition at page 130.
No, but regarding maintainability of this rate, your lordship may see that even the lead member has not come.
Yes.
Technically, the consortium has to come. These are pro forma opposite, pro forma response. So apart from that,
speaking, there is some question of any pro forma under the procedure or not.
That's it.
Is a judgment procedure, very old judgment reported in the notes.
in fact, it's a case of cancellation of tender. I've just got one of your lordship's recent judgments.
General penalty of rules are concerned. It has got a statutory backing. And if it permits or provides that when cancellation can be done under what circumstances, then is it not your obligation to say that what are the conditions? It is like a proposal. Take a part of the report. No. We report the border government government says. This paragraph. So far as division has said that this has the applicability because of the major contrast act which includes this rules to be
Now, we are in the process of floating a fresh tender.
Now they are saying that
They can always participate.
Cancellation can be interfered.
In fact,
there is.
I have got a recent judgment of 2025 of the Honorable Supreme Court. And your lordship's judgment also I'm giving, wherein your lordship has held that so far as the right to participate, they don't have a right. And it's a matter of cancellation. I'm giving the Supreme Court judgment, taking.
Said that normally we have cancellation.
Freedom should be given to them.
Here, my lord, there is no arbitrariness here. It's a case of cancellation for all. They can participate in the fresh tender which we are floating. There are financial repercussions also. So for administrative reasons, my lords, we can always have. We'll file a regular counter, my lords. We'll file a regular counter. First was there was a shortfall of documents by some of the bidders. That's one. And second is. No, that status is not correct. That's just. That's the.
That or depart from your
No, that is just the status. That is just the online status. And thereafter there was shortfall of documents. And second, my lords.
Is it not a second?
And second issue would be financial implication. Now here, if your lordship sees this judgment, of 2025 SCC online SC 933, paragraph 16 onwards, wherein the division bench of the High Court interfered and said that the cancellation was incorrect. Now, in paragraph 16, at page 6,
One judgment which we have delivered.
yes, that also I have given my notes.
Yes, no, not that one, where we considered all the.
All my notes.
God,
My notes.
we had some circumstances, the court may interfere in the.
Decision of cancelling the
With the or and over something. That is what we had.
That is in the case of RAPs construction. What is judgment of the RAPs?
Dear my lords, in para 16, they take note of Jagdish Mandal. The underlying portion, your lordship may kindly see.
Is it not?
No, my lords, the impugned issue is just the publication. In file, they have taken given this.
Show that what are the reasons. And whether it conforms to the ground which is now coming before the Bombay. That is, I think, infused into the court authorities. And under the major court of that.
Normally, my lords, in cancellation, your lordship's judgment also I have given, my lords.
Normally, we don't interfere because that freedom has to be given, but.
Here, my lords, my instructions are that there are financial implications. That, my lords, are executive instructions. We will file it. We will file it.
Statutory recognition.
The moment, my lord, there are financial implications.
Cancellation.
I know, we have considered all the judgments about and all.
Yes.
Every judgment that considered by us will be delivered on judgment.
Well, I try to look at under your lordship judgment.
No, we say
which matter?
In the RAPs construction company.
RAPs construction private limited.
Here in the other judgment also, your lordships have said that they have no right to participate. That concept still continues. They can always participate in the fresh tender, which is just round the corner.
That is.
Because I heard my learned senior submitting that we have to do it quickly.
This concept is accepted as a universal rule. Then under no circumstances, the decision to cancel the tender can be forwarded.
In fact, that's what it's very less. Here, my lords, we have not favored anyone. Justice Partiwala's judgment. That judgment I have seen. So now our instructions is that the next we found this to be financially unviable. Hence we are going for at a cheaper cost. So that's our instructions. If your lordship wants, we can file a short affidavit on this. Now this is regarding a green tender as my learned senior.
That is why the more importance has to be given.
So far as we are concerned, there is no interim application served on. Not paid for any interim.
There is a prayer, my lord, for interim relief.
There is no IA which has come, not been served on us.
Green petition contains the.
Kindly forgive me, my lord. Perhaps we should have done it, but my lord.
And in any case, there is one more writ which another company has filed. The consortium has not come before your lordship.
In other states, never, separate IA is never filed. It's a one composite application with an individual. Enough.
So, my lord, so far as this is concerned, the consortium hasn't come before your lordship. One. Second is this. So far as
People have recognized him as.
we do recognize that he is the one of the partners.
3 years financial documents from.
That was
Plus, had this not been, I would.
Created a mess.
So far as interim prayer, my lords, I would not have said anything had this not been for financial reasons.
Whatever.
Because the costs would be much lower. And your lordship division bench judgment recently has said that my lords, they have no right to participate in a tender. They have a right, they have no right to be considered. That portion my lord.
Please, I'm not, if they come up with this, but it's a question of cancellation. How do you have to give an answer to?
Your lordships very recently have categorically held that it is within the domain of the authorities to cancel the tender, and mere participation in the bid does not create any vested right into an intending bid.
Say, where is the difficulty?
We'll file a short affidavit.
Again, I'm saying if this GFR could not have been here, the position.
Your lordship may keep it to next week. We'll file a short affidavit. Let it come with the other
You
writ.
will say, but don't, then we can close the writ.
Yes, the problem is this relates to a.
Problem you can't. You can't have a cake on both hand and eat both.
Since 15th April 2025, my lord, friends have waited. Now, my lord, they can't wait for 1 week.
Then your lordship may keep it to this week, any date. I'll file a short affidavit. Thereafter, your lordship may come. First of all, so far as the fresh tender, which is in the process, they can always participate. And your lordship recently have said that.
Let us pass the order. If your stand is the such, then.
No, my lord, may I submit one thing? Your lordship may keep it to any day this week.
Then it will be Monday, because the Monday is the date for voting.
Then your lordship may keep it to next Monday. I hope they don't float this thing. And we'll give them.
We can't float anything. Not within
a recording. This is like that. Go as well.
Okay, that.
Yes.
I would leave it to you. Had it not been a cancellation matter, I wouldn't have insisted so.
Then they need to order.
Looks first, once when it's Monday, I pray, let it come maybe at 2 p.m. if my urgency is there. We'll be a short affidavit. Again.
So we are giving you an opportunity to file an affidavit, but only a thing is that if it is done, then what?
Once your lordship stays, then this has repercussion members, and I am told that the
Give an assurance or advice, whatever, the word. You tell me if you use that.
I will advise them. Your
So
lordship
this
may
is
keep
not
it.
a source. Says that even advice is right not to.
Let it come Monday on top of the board. Can I request?
Let the court authority file the affidavit.
No, but
Let it
Monday,
come on
then I
Monday.
have no opportunity to
Counter affidavit before that.
Before, in the course of this week, we would file.
Because of this week.
Well,
Friday?
by Friday.
Friday. The copy where, the copy whereof shall be served upon the advocate and record appearing for the solicitor on the same day. Is the matter Monday taken up any first hour or?
And 2 p.m. 2 p.m. would be more convenient.
Well, they only make one when an humble prayer. The other petition, my lord, will follow the same order. My lord, let that also be listed, my lord, and similar to.
Let them give a number like.
Very.
Before your
Number is always.
one request. Extreme order.
If the extreme order is there.
Rest of the